Good afternoon. Welcome to the House Judiciary Committee. It's Wednesday, the 22nd of February, 2023. We have 5 whole bills today, and we're going to get started. Delegate Kaufman would like to introduce someone in the audience very quickly.
Yes, Mr. Chair, it's my distinct honor and privilege to introduce to you my uncle, Marty Ellen, who's currently the acting executive director of the Georgia Innocence Project, and previously was the executive director of the Atlanta Volunteer Lawyers Foundation, so he'd fit right in with this committee. Thank you for being here all the way from Atlanta, Uncle Marty.
All right, that's fine. Okay, we're going to get started with the St. Mary's Delegation Bill, House Bill 526. Delegate Morgan is here. He's the only one who's testifying on this bill, and so let's hear from him.
I promise to be quick, Mr. Chairman. Hi, my name is Delegate Matt Morgan, here to present to you House Bill 526 on behalf of the St. Mary's delegation. The bill has delegation support and local support. And what we had here is an election last November, and our long-term state's attorney, that office changed, elected officials. So with incoming I would call it a new administration, they wanted some realignment done as far as our department goes. So it's brought to our attention that St. Mary's was still the only 3 counties in the state that handled child support enforcement in their local state's attorney's office. So what this bill does is a legislation that would transfer the child support unit, including all its current employees, to the Department of Human Services. All employees would be switched to equivalent pay grades within that department. There is some amendments. I do have an amendment for the bill. And the amendment, we had a problem in bill drafting, trying to figure out when was the best time to implement this. And it goes into effect, I believe, October 1st. So with that, I'd be happy to answer any questions that you may have.
Vice Chair.
Thank you, Mr. Chair. Sorry, I'm just reading the fiscal note on this. And the way this looks is that the St. Mary's County government is essentially getting a $300,000 a year subsidy through the transfer of these functions from the county to the state. And I guess fundamentally, I don't really have any problem with that. But I guess I'm curious if all the other counties who, I guess at one point, maybe the counties all did this and then transferred over to a state system. So I guess I'm just curious if all the counties are being treated the same with respect to the savings on this.
Yeah, I saw that in the fiscal note. I'm not sure. I do know that we're one of the last counties that handles it locally in our state's attorney's office. I'm not sure. The fiscal note didn't even tell me what the other 2 counties were. So I'm not sure
Yeah, no, it's funny. I'm like, well, I sure would love to bring a whole bunch of Montgomery County bills and get local courtesy and transfer the county costs over to the state. But it sounds like we're already doing this for everybody else.
I agree.
Delegate, does the state's attorney support this?
Yes.
Okay.
And there should be is there not a letter in there? If there's not,
I don't have it. Doesn't mean it doesn't exist. It's probably in the computer.
Yes, she does support it.
Okay. Are there further questions? Seeing none, thank you very much. That concludes the testimony for House Bill 526. We'll go now to Delegate Tolles to House Bill 672, and we'll hear from her, Scott Poyer, Karen Bushel. The delegate for 3 minutes, everybody else for 2.
Good afternoon, Chair Klimpinger, Vice Chair Moon, and my fellow colleagues of the Judiciary Committee. I'm here to testify in support of HB 672, Mayor's Ceremony, Designation of Deputy Clerk. So, this is not only Black History Month, but also the month of love. And in that spirit, I ask for a favorable report on HB 672. Now, HB 672 is a straightforward country bill. My colleagues from last year know what that means. It's not a shotgun marriage bill. This bill transfers the authority to designate a deputy clerk to perform a marriage ceremony from the county administrative judge to the clerk of the circuit court for the county. Deputy clerks of the circuit court currently have permission to perform civil marriage ceremonies in the state of Maryland under the authority granted in Section 2406 of the Family Law Article. And although the deputy clerks have the permission to perform the ceremonies, the approval to do so still must come from the administrative law judge. The aforementioned is an unnecessary bureaucratic step and infringement of the authority of the clerk to direct the work of their own staff. Elected clerks perform thousands of ceremonies a year. HB 672 would allow for more flexibility for the elected clerks to manage how they carry out marriage ceremonies in their respective counties. Lastly, as you can see in the fiscal note, it has no impact on local and state operations. I respectfully ask in this month of love for you all, my dear colleagues on the Judiciary Committee, to give a favorable report on HB 672. Thank you, Mr. Chair, and I'm happy to entertain any questions.
Thank you, Chairman Clippinger, Vice Chairman Moon, and members of the committee for this opportunity to testify in support of HB 672. For the record, my name is Scott Poyer, Clerk of the Circuit Court for Anne Arundel County. And the clerks of the Circuit Court for the state of Maryland ask for a favorable report on HB 672. Currently, judges, clerks of the Circuit Court, and deputy clerks are authorized to perform civil ceremonies in the state of Maryland. Judges and clerks have direct authority to perform civil ceremonies, but deputy clerks must be designated by the administrative judge in each county. This means that even though the clerks have direct authority to perform marriage ceremonies, we must request and receive approval if we would like to designate one of our staff to perform marriage ceremonies. There's seldom, if any, in disagreement between the clerks and the administrative judge. However, we do believe, as Delegate Tolles mentioned, this is an unnecessary bureaucratic step and an infringement of the authority of the clerk to direct the work of our own staff. In a jurisdiction such as Anne Arundel County, with a staff of over 120, I must request an administrative order requesting the previous order be rescinded and a new order be issued designating my staff to perform marriage ceremonies. It should also be noted that the elected clerks of the Circuit Court are not required to seek such designation and approval with any of the other matters that are before us as clerks. So therefore, the Circuit Court clerks hope that you will give a favorable report to HB 672. Thank you again to Delegate Tolles for sponsoring this, and I'm available for questions.
Thank you, Chairman Clippinger, Vice Chairman Moon, and members of the committee for this opportunity to speak to you in support of House Bill 672. And for the record, my name is Karen Bushell. I am the clerk of the Circuit Court for Montgomery County. The clerks of the Circuit Court support HB 672, transferring the authority to designate a deputy clerk to perform a marriage ceremony from the county's administrative judge of the Circuit Court to the clerks of the Circuit Court in each county. Generations ago, judges were involved in performing marriage ceremonies in Maryland. In the 1700s, weddings that were not performed by clergy were performed by judges. However, since at least 1963, this function has largely been transferred to the clerks of the Circuit Court. And today, the clerks and our staff issue approximately 30,000 to 40,000 marriage licenses and conduct 10 to 20 marriage ceremonies per year. The only involvement of judges these days is in the performing of an occasional marriage ceremony themselves, which may amount to a couple dozen a year. As a practical matter, the clerks believe that allowing us direct authority to designate our staff to conduct wedding ceremonies that our office is responsible for would be more efficient and better reflect the current practice. The Circuit Court clerks hope that you will give favorable report on HB 672, and we would like to thank Delegate Tolles for sponsoring this bill. Thank you for the opportunity to comment, and I am available if you have any questions.
Are there any questions for this panel? Delegate Boucher.
Delegate Tolles, thanks for bringing this forward.
Of course.
You know, the Maryland Judicial Conference weighs heavy on me. I see they didn't weigh in on this. Would that mean that they are supportive?
Can I turn to my esteemed panel to ask them
Yes,
that
ma'am.
question? Thank you.
The judiciary's taken no position on it. I think all we're trying to do here is just cut a little bit of bureaucracy and red tape.
Well, then that works for me. Thank you.
Perfect.
Thank you, Mr. Chairman. Thank you, delegate and witnesses to come in and testify. To the delegate, did Baltimore City Clerk of the Court weigh in on this bill?
We do represent all the elected clerks in the state of Maryland, including the elected clerk in Baltimore City, Xavier Conway.
Yes.
Yes.
And how does the clerk designate who's going to be able to do these marriage ceremonies?
You may answer. Yeah.
Could you repeat the question, sir?
How does the clerk designate who's going to do the marriage ceremony?
I can answer that, and then I'll turn to the panelists. I mean, the clerks have deputy clerks, and they have a department, certain clerks that do only that work within their agency. And so those deputy clerks, that they already do the work, they just cutting out that middleman so that you don't have to go to the administrative judge to say, can you give me permission? They're pretty much already doing it. So every time someone requests it, if the clerk can't do it and they have to deputize someone, they're deputizing the people they've already trained and to do that work already. But it's just cutting out that middleman. So they have a specific group of people in their office or deputies that do that work already. And if you want to add, I don't know, to that.
Well, what I was trying to get to was, can the clerk appoint someone, a deputy clerk, to perform a ceremony that the deputy clerk might not want to perform?
The clerks appoint the deputy clerks to do the work, so the deputy clerk wouldn't turn around and point like someone else in their staff to do that. Is that correct?
That's correct.
Okay.
Yes.
Exactly. Okay. Thank you very much.
You're welcome.
Anyone else? Seeing none, that concludes the testimony on House Bill 672. Thank you very much.
Thank you.
Thank you.
All right, we're now going to go to House Bill 687. Delegate Cardin, he can be joined by Christia Pritz, Deb Howe, Sarah Call. All of them should be here.
We just have two of us.
Two of
Two of my
All right,
panel.
that's fine. 3 minutes for you, 2 minutes for
Thank you.
everybody else. Go
Thank
ahead.
you, Mr. Chair, members of the committee. Hopefully this will be a very simple bill. House Bill 687, I'm asking for your favorable report. For the record, John Cardin. This is really a bill about competitive, the way I see it, it's a bill about competitive advantage. And my panel will describe the details of why it's necessary. But suffice to say that right now, so while there is no express statutory authority that permits decanting in Maryland, and decanting just means taking a trust that is in existence and then distributing to another trust for the same benefit to the same person. Is that right? Okay. And that would be what decanting is. There's no statutory authority to do decanting, although there is limited ability to do that now. And what this bill would do would create a statutory authority to do that exact thing. 33 states already allow this, and those are the states that attract trusts, particularly large trusts, because of the stability, flexibility, and clarity of their trust law. And so what we want to do is we want to be able to compete with those to retain Maryland trusts in Maryland so that we can get the benefit of having that kind of those types of situations and those types of financial implementations in Maryland. And so I think that we should pass this bill. And I will give it to my esteemed panel, Mr. Chair.
Thank you, Mr. Chair and members of the committee. My name is Sarah Call. I am the chair-elect of the Estate and Trust section of the Maryland State Bar Association, here in support of House Bill 687. Much of Maryland trust law is about following a settler's intent. Typically, that intent is to improve the life of a beneficiary, yet there can be times when Following the letter of the trust will frustrate that purpose. Changes in the law, changes in taxes, and changes in the circumstances of beneficiaries can all result in a trust that is inefficient or, in the worst case, does more harm than good to beneficiaries. An option for trustees, as we just heard in over 30 other jurisdictions, is to decant the trust from one into another with similar terms. Those similar terms could correct an unforeseen circumstance, like an upcoming distribution to a beneficiary with an addiction, or a trust failing to qualify for a tax benefit based in the change in the law. House Bill 687 is based on the Uniform Trust Decanting Act, and about a dozen or so other jurisdictions have a law based on the Uniform Act. The trust and estates community is excited about trust decanting in Maryland because we do not want to have to move our trusts out of Maryland in order to be able to use decanting to fairly and efficiently resolve problems. I am guilty of having moved trust into other jurisdictions, and I know that my colleagues are as well. Some of my colleagues also believe that trust decanting is available under common law already, and for those people who believe that that is the case, they are doing so without the protections that House Bill 687 would provide. And those protections are important. We, as a committee, represent settlers and trustees and beneficiaries, so all of their interests are important to us. A trustee can't just take any trust and change it to whatever they want. I know that this is a technical bill, so we're happy to answer any questions or follow up later. But for those reasons, we ask your favorable report for House Bill 687. Thank you.
Thank you, Mr. Chair and members of the committee. My name is Christia Pritz. I'm the Secretary of the Estate and Trust Section Council for the Maryland State Bar Association, and I'm here in support of House Bill 687. One of the concerns that sometimes come up about decanting legislation is whether the trustees having the power to decant might be an opportunity for them to override the settler's original intent in creating a trust or do something that might harm the interests of beneficiaries. However, the Decanting Act actually has several protections built into it with regard to these issues. As always, a trustee is required to act in accordance with his or her fiduciary duties, such as the duty of care, the duty of loyalty, which includes a duty to act impartially in the interests of the beneficiaries. The Decanting Act specifically requires that the trustees act in accordance with the purposes of the first trust. This means that when determining whether to decant, the trustee must take into account the settler's intent in creating the original trust and exercise the power only in a manner that furthers those purposes. The trustee is also required to give notice of the decanting to the settlor if he or she is still living and to the beneficiaries 60 days prior to decanting the trust. And so this is so that they are aware of the trustee's intentions. If the settlor or a beneficiary believes that the trustee is abusing his or her discretion, they can file a court petition in an attempt to stop the decanting. As Sarah mentioned, we represent all of these parties, settlers, beneficiaries, trustees, and we believe that the interests of all of the parties are adequately protected by this legislation and that there are sufficient checks on the trustees' powers. We therefore urge a favorable report for House Bill 687.
Mr. Chair, there's no opposition to this bill.
Are there any questions? All right, seeing none, we thank you very much, and that concludes the testimony on House Bill 687. All right, we're now going to go on to my bill, House Bill 824. I'm going to take it from here, and then we'll have witnesses who get up both favorable and favorable with amendments, and then we'll hear from the unfavorable panel. Members of the committee, I'm here to present House Bill 824, legislation that brings our wear and carry laws into compliance with the Supreme Court's decision in Bruin versus New York State Rifle and Pistol Association. Last year, the Supreme Court held that state laws used to determine whether someone receives a permit to wear and carry a regulated firearm cannot include language that requires a person have a, quote, good and substantial reason to get one of those permits and to wear and carry that regulated firearm out in public. This legislation removes the good and substantial reason language from Maryland law while also making changes to both our wear-carry permit process and to the process for getting a regulated firearm that I believe will strengthen public safety. The legislation does the following. It both prohibits the possession of a regulated firearm and procuring a wear and carry permit if a person is first on supervised probation for a crime with a maximum penalty of a year or more, supervised probation for any DUI or DWI, or supervised probation for violating a protective order. Someone would have been convicted of those crimes, and they would have been put on probation by the court. Probation can go as long as 3 years in the district court and 5 years in a circuit court case. Also, they would not be able to either possess a regulated firearm or have a wear and carry permit if they were convicted of our current laws with regard to child storage, and the gun was used to kill or engage in serious bodily injury of another. A person who has been convicted of that existing crime more than once would also be banned from either possession or from a wear-carry permit. A first-time conviction of the storage laws that we have would result in a 5-year prohibition. It limits the wear-carry license to those people who are over 21, just as 34 states in the District of Columbia do. It also moves and copies language from our existing possession statute that says that the person cannot suffer from a mental disorder or have served more than 30 days consecutive in involuntary hospitalization in a mental hospital. The bill also says that a person cannot get a wear and carry permit if they're subject to a protective order or a red flag protective order, or an ERPO. It strengthens the training covering self-defense law, justifiable use of force, deadly force, proportional use of force, and conflict de-escalation. I have 5 seconds, so it raises the fee, it deals with data collection, it requires 2-year renewals, and it requires the state police to revoke a wear and carry permit if someone fails to meet the regulation. I'm happy to take questions from the committee right now, and then we'll have people who are going to testify on both sides of it. I want people to feel comfortable asking me questions, but I figured we could do this part of it now and then have people come up to the table. Delegate Boucher.
Thank you, Chairman. Thank you for bringing this bill forward. I'm interested in the structure of the fee process. What is the methodology behind it? Thank you.
So right now it's $75 to get to apply for a concealed carry permit. It's $50 if you're renewing your concealed carry permit right now under current law. Under the bill, it would raise those to $150 and to $100. We haven't raised the fee since 1992. And in this fiscal year, we spent $20 million out of the licensing division to process the applications and do other work related to licensing at the Maryland State Police. And as we learned earlier this year, we had about 100,000 applications go through. We don't necessarily know how many of those were renewals and how many of those were first-time applications, but presuming they were all first-time applications, the $75 times 100,000 would be about $7.5 million, so there's a gap there. To be clear, the money that goes in and the fees is paid into the general fund. It is not specifically allocated to that account. Having said that, we're trying to stay within the bounds of what the actual cost to process the licenses are.
Thank you, sir.
Right. Delegate Bartlett.
Well, Mr. Chair, I don't really have a question, but I just wanted to ask you something because we had this opportunity and we rarely have this opportunity. So the bill, do you think
favorite color is blue?
Right.
All right.
So do you think the bill will be beneficial and helpful?
I think that what we first have to do as we're entering this area of the law, as we're talking about this area of the law, we have to change the way that we license people to wear and carry firearms. And so that's what this seeks to do. It seeks to also make clear in the law people that we don't want to have these permits, and include those people who, whether they've violated a protective order or are on the are on the receiving end effectively of an existing protective order. That's all consistent with our law, and it's consistent with regulation that the Supreme Court in Bruin has said is perfectly fine under the law. In fact, Judge Kavanaugh kind of went that far and said, the kinds of things that are in this bill are the things that are still fine under the law. Delegate Cardin.
Just confirming on page 6 of the bill, I think it's like line 15 or something, 14, that you cannot possess if you've been convicted of if a person has been convicted of a violation of 4-104, the criminal law article, may not possess regular firearm. I don't know if it's just that section or maybe other sections. PBJs, and are those included or specifically excluded, number one. And then number two is we had testimony during a briefing, not during a hearing, that in order to qualify for both for the HQL as well as for aware carry, the maximum amount of training, actual shooting training was, I think, there was testimony that said 16 rounds, and there was testimony that said 25 rounds.
25 rounds.
That seems to me to be a very, very low amount. You have to shoot a gun 25 times to be able to get a wear carry permit. Can you talk about whether that's going to be required annually, hopefully, or?
You've given me two questions. So first, 4104 in the criminal law article is the current law with regard to storage, the storage of a firearm as it relates to whether a kid can get access to the weapon. Throughout the bill, it talks about a conviction, which under our law and in all of our conversations here, conviction means conviction. It doesn't mean PBJ. So they'd have to be convicted. In the bill, it says that a first-time conviction, if no one else gets hurt by the gun, if it's not used by a child to hurt somebody else with the gun, the first time would mean that they would be banned from wearing and carrying and possession for 5 years. If they did it a second time, they had a second conviction, or if on the first time somebody were killed or serious bodily injury, then they would be banned. On the second question with regard to the training, we did hear it was 25 shots, I think is what the state police, I remember writing down 25 shots, and they had to have 85% proficiency or better to do that. This bill doesn't change that. It talks about that a person needs to be able to demonstrate safe handling of a handgun and shooting proficiency of a handgun. So we're effectively deferring to the state police on that. Yeah.
Will they be required to have ongoing training, right?
So what this does is it requires them to reapply every 2 years, and part of that is the training course. There are some people who don't have to do that, and those are already in current law, and that's people who are law enforcement officers, retired members of the military, or they themselves are a qualified handgun instructor. They don't have to go through
right,
that.
but the people who are not exempted will have to show proficiency every 2 years.
That would be my understanding under the bill.
Thank you, Mr. Chair.
Yes. Delegate Arakan.
Yeah, so I just want to make sure I understand. It seems like a lot of folks having shotguns. So would this bill require that I reprove I know how to shoot a gun, ride a bike every 2 years? Because essentially that's kind of the vibe I'm getting, that I would be required to show again I still know how to shoot a gun. That seems totally insane to me.
It says they have, if they've already done the course. Yeah. So under B4, I've spoken error before. Under B4 of existing law, and this bill doesn't change that, if they've completed a firearms training course approved by the secretary, they wouldn't have to go back and do it again.
Okay, that makes a lot more sense.
This issue has been an issue, though, that has come up in the committee several times. And if people want to talk about, what that would look like, I'm open to it, just being completely candid with you. I don't know exactly what that would look like going forward, but there is this tension in our current law between the 25 shots that people have to take and prove 85% at one point in time, and the need to demonstrate continuing proficiency with a gun.
Okay.
One of the things that I do think we need to talk about, and it's bad to start talking about it in comparison with what we do with driving, but people's ability to drive starts to change as we get older, and things change, and we require glasses and things like that. I don't know if it would be necessarily a bad thing to consider what that would mean going forward, but as of right now, what's in this bill is it stays the way it is.
Good. Hopefully, before we make those kind of changes to the law, we would have everyone in here actually take the course, get a concealed carry license, and start carrying and shooting so that they could be best informed on how hard it is to lose your ability to shoot once you've already been trained. That would be awesome.
Delegate Boucher.
How often do active law enforcement now have to requalify for live shooting, and how many rounds do they have to discharge? Does this bill equate to that, or is it different?
This bill doesn't directly address that. I need to get you the answer to that question because it just popped out of my head. I'll be happy to get back to you with the answer.
Thank you, sir.
All right. Delegate Kaufman, please.
Just wanted to say, first of all, to the Moms Demand Action folks in the office, in the audience rather, that I think the chairman has written an extraordinary bill, and I would have co-sponsored it, except that the day you dropped it was the day of my brother's funeral. So, well done, Mr. Chair. My question for you, though, is some people are pretty excited about this bill in a negative way. They say, in this one testimony from Second Amendment, Maryland, they say HB 24 is a mashup of every conceivable means to prevent Maryland citizens from obtaining a permit and on and on. And so people are very exercised about this, but I think I wanted to give you a chance to respond and say, I think your approach is pretty moderate. Would you agree with that?
I didn't plant the question. That's the best part. I didn't plant the question. Look. First of all, I think that what I have tried to do with this legislation is strictly address the outlines of the permitting process and stay within the permitting process. There are other conversations that are dealing with broader issues about sensitive places and other things. But what I've tried to do here is stay within the bounds of the law and effectively build on what we have already passed in Maryland law, which the Supreme Court has already indicated that they don't have a problem with. So in the area, again, of the supervised probation, looking at, there's already rules that say if you are a habitual drunkard, a term that is defined in Maryland law, that is a restriction on being able to get a handgun. This goes a little bit farther by saying if you're on probation for having a DUI or a DWI, we don't want you to be able to possess a firearm or get a wear-carry permit. If you have violated a protective order, we don't want you to be able to possess a firearm or get a wear-and-carry permit. And for the main reason being, you are demonstrating a risk of violence in the community. And that's something in the Supreme Court's opinion and in the jurisprudence that has been consistently upheld.
And just briefly, Mr. Chair, if I could quickly follow up. Could you repeat, because I think it bears repeating, what Justice Kavanaugh, a Trump appointee, said? Because I happen to miss that.
So in Bruin, Justice Kavanaugh indicated that comparing the shall issue jurisdictions with may issue jurisdictions, not just Judge Kavanaugh, but the Chief Justice went out of their way to say that those shall issue regimes, the states that have shall issue laws, may require a license applicant to, quote, undergo fingerprinting, a background check, a mental health records check, a training in firearms handling, and in laws regarding the use of force, among other requirements. I think very clearly that Judge Kavanaugh, and I mean, again, two of the votes that got this to 6 on the Supreme Court, very clearly said first that the Bruin ruling was limited to that part of New York's law, that addressed whether it's a may issue or shall issue, but also left the door open for states to be able to appropriately regulate in this way.
I appreciate the wisdom of my constituents, Chief Justice Roberts and Justice Kavanaugh. Thank you, Mr. Chair.
Oh, right. To answer Delegate Boucher's question, law enforcement under the concealed carry law do not have to complete the firearms training course at all. If your question is to how often police officers have to go through that again, that's a different question. We're going to get the answer to that. Delegate Phillips, did you have a question? Your light went off. No, you don't? Okay. Are there other questions? Delegate Conaway, hello.
Thank you for acknowledging me, Mr. Chairman. You don't have to look at me in that manner. I was wondering on page 2, so if my bills
Now
go
I'm
down, you know why.
but okay.
Okay. So on page 2, lines 8 through 10, would the firearm also include the receiver, this definition?
So again, what's your question?
Would the firearm, because it's
We're talking about a regulated firearm.
right, but didn't we include the receiver of a
I
firearm?
think we did
to be
receiver.
included?
I'm trying to remember what we did with receiver in the context of the ghost guns bill from last time. Yes, it's a regulated firearm.
So does that need to be specifically named, or would that come under?
This is coming,
or any other firearm?
this would be, it
What
would
I
be
was
part
trying
of
to
the
get-
definition of regulated firearm. So, and that's what we're dealing with the wear carry side of it and with the possession, only dealing with regulated firearms, not dealing with anything else.
So the receiver is not considered to be a regulated?
Yes.
So should the receiver be named specifically in here, included with the other firearms?
I'll be happy to look at that and talk to you.
I was wondering if you would entertain an amendment for my good friend and Delegate Kaufman, and possibly myself.
All right, well, I'll be happy to speak with you more about it.
Thank you very much.
Absolutely. Delegate Tomlinson.
Thank you, Chairman. I'm just looking at some of the unfavorable testimony, and I know they'll be coming up later today. In Maryland Child Issues testimony, they mentioned about the doubling of fees being likely unconstitutional, and that the doubling of fees wouldn't survive judicial review. Is that accurate, or?
The rule, as I understand it, is that the fees that can be charged have to basically match the costs that are being incurred by the regulatory body. And what we looked at and what we saw now in fiscal 23 is that it cost the licensing division cost about $20 million. As we learned in our previous hearing, or in our previous briefing, there were about 100,000 applications that went through. We don't know how many of those were initial applications or how many of those were renewals. Right now, the initial application is $75. The renewals are $50. Even if they were all initial applications, that would be $7.5 million against the $20 million. There are additional costs that I think are going to have to be, that should be rightly addressed. I don't think that, yes, it doubles the fee, but at the same time, I think it doubles the fee so that we can actually meet the costs that are being incurred by the licensing division, and for that reason, I don't believe that it's unconstitutional.
Thank you.
Just checking with Delegate Conaway again, because I didn't want to get yelled at. All right, are there any other questions for me? Seeing none, then we're going to go on and we will start taking testimony from those people testifying in favor and in opposition. I'm going to go, that's what we'll do. So I'll call Andrea Chambly, Peter Benjamin, Clinton Walcott, Karen Herron, and then we'll take the first two virtual, the only two virtual in favor, Tanya Shart and Samuel Levy. So if those four people would come forward. And whoever would like to go first, usually start at my right, your left, and move across, that would be fine. So, right there.
Thank you. Good afternoon, Chairman Clippinger, Vice Chair Moon, and members of the committee. My name is Andrea Chambly. I don't usually say where I live anymore because the "we shall not comply" people show up at my door, and I don't want them to break into my house again. But I'm in District 9, and I'm a volunteer with the Maryland chapter of Moms Demand Action. I'm here in support of HB 824, and I ask for a favorable report. I'm sitting here hoping that no one else will ever have to sit where I'm sitting. At June 28th, 2:38 p.m., about 5 years ago, a man with a criminal history of violence walked into the Annapolis Capital Gazette. He had spent years terrorizing the Capital Gazette staff with deadly threats after they reported on his crimes. He had a criminal record of violence against women that had been expunged in return for his showing up at anger management classes. Despite his record of violence and his ability to manage his anger just fine when it didn't involve someone who was turning him down for a date, and his lackluster attendance at these classes, those classes were deemed adequate. He got his record expunged, he was able to obtain a gun, and in doing so, he changed my life, our lives, and our town forever. The decision by the U.S. Supreme Court in Bruin greatly weakened America's concealed carry laws, and we must take steps such as this bill, HB 824, to ensure that guns do not wind up in the hands of people who pose a danger to themselves or others. The emphasis on this bill is simple: making sure the permits needed to carry firearms are issued only to responsible gun owners. It contains objective requirements such as safe handling and proficiency that are nothing more than the minimal requirements a responsible gun owner should welcome. These are important safeguards because we know that more guns in more places only increases the likelihood of an argument or disagreement escalating into a shooting. I ask the committee to issue a favorable report on HB 824. Thank you for your time.
Please.
Good afternoon. I am Karen Herron, Executive Director of Marylanders to Prevent Gun Violence, here in support of House Bill 824, addressing regulated firearms, possession, and permits to carry, wear, and transport a handgun. As has been highlighted, the purpose of this legislation is to strengthen Maryland's laws pertaining to what items disqualify someone from possessing and being allowed to carry a firearm. It does this by adding some additional disqualifiers where someone has demonstrated that they are not likely to be a responsible gun owner, modifying renewal periods, requiring regular review, and codifying more specific training requirements. We acknowledge that the Supreme Court's position that the ability to carry firearms outside the home is entwined with their view of the Second Amendment, but it cannot be doubted that doing so is an incredible responsibility, and it is not one that everyone is cut out for. On Valentine's Day of 2022, a couple in Texas were at a drive-through ATM when they were accosted by an armed robber demanding their valuables. After the couple complied, the robber ran away. The husband then exited his vehicle with his firearm, shooting at the back of the retreating assailant. What he hit instead was a vehicle traveling past with a 9-year-old girl in the back seat, who was shot and killed. The responsibility of what it means to carry a firearm into a public space is not one to be taken lightly and not without adequate training. This bill addresses some critical behaviors in determining suitability for firearm possession by wrapping into prohibitors behaviors which demonstrate an inherent unsuitability for possession of firearms, such as driving under the influence, violating protective orders, and safe storage violations. MPGV urges a favorable report on HB 824.
Chair Clippinger, Vice Chair Moon, and members of the committee. I'm Clint Wolcott. I'm here representing the Critical Issues Forum, a coalition of 3 Montgomery County synagogues, includes over 1,700 households. HB 824 is a necessary piece of legislation for this session of the General Assembly. We must maximize the tools that the Supreme Court's Bruin decision allows to make handgun wear and carry permits safer. In addition to expanding firearms training and the crimes that lead to denial of a permit request, as this bill proposes, we should also give the state police the tools and the responsibility to screen out dangerous individuals who have not been convicted of a crime. As the chair noted, the question of what sensitive areas handguns should not be permitted is not part of this bill, but that it's also a critical aspect of what this committee and the legislature should deal with this year. The issuance of Bruin has prompted an alarming increase in wear and carry permit applications from a little over 18,000 in 2021 to 101,000 in 2022, a 446% increase. The state police recently testified before this committee that because Bruin forbids them from examining whether applicants have a substantial reason to be granted a permit, they have discontinued doing the interviews of applicants that they did in the past. This is a tool that would help to carefully screen out dangerous applicants. This tool should be maintained by the state police and adopted. We urge the committee to produce a favorable report on HB 824. Thank you.
I'm Peter Benjamin. I live in Garrett Park in District 18. I'm a member of the Montgomery County group of the Maryland chapter of Moms Demand Action for Gun Sense in America. I'm here to testify in favor of HB 824. The chairman has very carefully indicated what has happened by the Supreme Court nullifying the criteria in New York that established conditions for carrying guns in public, what was called the Bruin decision. And he has noted that this also affects the Maryland law and says that this is something that we need to change at this point. SB 1, which is also under condition in this legislature because of the Bruin decision, establishes where guns cannot be carried legally. HB 824 identifies the criteria for issuing a permit to carry a gun. The combination of these bills together may provide an appropriate response to the Supreme Court's Bruin decision. We know that carrying a gun provides the opportunity to use the weapon quickly for self-protection. That may or may not allow for time to consider whether using a firearm in a specific situation is appropriate. Last Friday, two men got into an argument on a Metro bus in Montgomery County. One pulled a gun and shot the other. Anger, such as road rage or an argument over political differences, can cause someone to potentially pull a gun, if they're carrying one, and do so in crowded conditions with innocent bystanders. When guns are easily available, we need criteria for determining who is given a permit to carry a firearm. HB 824 would deny permit to the categories of people discussed by the chair. I recommend a favorable report on HB 824.
We could hear Tanya Shart next, testifying virtually for 2 minutes, and then Sam Levy.
Good afternoon. My name is Tanya Shart, and I'm Senior Counsel and Director of State and Federal Policy at Brady. Thank you so much for the opportunity to speak today in support of this bill. Maryland leaders have persisted in prioritizing the safety and well-being of the people of Maryland by enacting and implementing proactive and research-informed policy solutions that prevent gun violence, save lives, and spare entire communities from lost trauma and cycles of violence. In the wake of the dangerous and wrong Supreme Court decision in Bruin, which invalidated part of Maryland's concealed carry permitting system, we are urging this body to yet again prioritize public health and safety by passing this bill. As you have heard, it has been reported that Maryland State Police have received over 400% more wear and carry permit applications in 2022 than in 2021. This is a jarring number, and absent action like this proposed in this bill, those living in and visiting Maryland will be faced with a reality where guns are everywhere, being carried by those who have not been properly trained or vetted. This bill enhances the wear and carry permitting process to ensure that those who carry firearms in public are at least 21, have proper, adequate, and specific training, and have not been convicted of crimes or are subject to any orders that are reflective of increased risk. This is common sense, and as has been explained, this is all constitutional under Bruin. It will create an environment where Marylanders can feel safe, and most importantly, it will save lives. Because rigorous studies of concealed carry laws found that in states that had weakened their laws, violent crime rates rose 13 to 15% after 10 years. We cannot allow that to happen in Maryland. Thank you to the chair for your leadership here, and I respectfully urge a favorable report of this bill. Thank you so much.
Mr. Levy, please, for 2 minutes.
Thank you, Mr. Chairman. Thank you, Vice Chair Moon, members of the committee. My name is Samuel Levy. I'm a Regional Legal Director at Everytown for Gun Safety, and I'm grateful to be here today to urge a favorable report on House Bill 824, and also note a few additional things that I ask the committee to consider as you move the legislation forward. As you heard, the Supreme Court's decision in Bruin was dangerous, it was wrong, and it significantly lowered the bar for what it takes to get a permit to carry a hidden concealed handgun in public in Maryland and in 6 other states. It's going to have a whole host of other ramifications for gun violence prevention laws that we'll be dealing with for years, but House Bill 824 is a surgical and smart and direct response to one particular danger that decision created, which is, what does it mean now to have a system where you can no longer require that applicants for a wear and carry permit demonstrate that they have a good cause to obtain one? And the answer is simple. It's addressing and updating and strengthening the provisions in the law that have long existed in the Maryland Code that, as the chair pointed out, have been endorsed by the court's opinion itself, that were upheld at the Supreme Court level. And those are very standard and common sense steps, right? A thorough list of who's prohibited that tracks, obviously, the state's prohibitions on who can possess a gun at all, much less carry it in public. Questions of training to ensure that you have the ability to handle that weapon safely, to know how to use it, to store it, what state laws are applicable to carrying in public. And of course, the questions of training and de-escalation to ensure that when those guns are carried in public, they're not used improperly. I only flag 2 additional things to consider. One, which has been said, is of course, more permits means more guns in public, and that means more imperative to assess your state laws with respect to sensitive places and places where even wear and carry permittees cannot bring their firearms. And the second is the investigation portion to identify people with a propensity for violence or prior dangerous conduct. I think adding some more robust detail in there to guide the Maryland State Police in their inquiry would be useful and helpful to ensure that the process is transparent and clear and consistent. And I urge a favorable report. Thank you, Mr. Chairman.
Questions for this panel, please. Delegate Williams.
Yes, thank you, Mr. Chair. I guess the question I had, I heard it come up a couple times about SB1, and I don't think we've heard SB1 here yet in our committee. And so I think there was mention about sensitive places, and forgive me, I read the Bruin decision a couple months ago, so it's not fresh in my head. But I believe, like, in our state law currently, and I'm looking specifically at the criminal law article 4-208, it talks about places in our current law already where the possession of a firearm is already prohibited. And so you mentioned the sensitive places argument that was, I think, raised in the Bruin decision, but my understanding with the Bruin decision, the New York statute wasn't struck down because of the sensitive places issue. It was struck down because of the subjectivity of the law in the state of New York as related to obtaining the concealed carry permit. So I guess I'm just trying to understand why we have to deal with the sensitive places argument, since that wasn't the reason, or at least from my recollection, correct me if I'm wrong, my recollection in the Bruin decision that wasn't the concern raised about the New York statute.
Delegate Williams, I was a person that mentioned SB1. I think it would be better when this bill is considered, when SB1 is considered in this committee, to have somebody who actually was part of the preparation of SB1 answer that question. Karen, would you want to say something?
I was going to defer to Sam Levy, who is by far the expert on this topic.
Okay.
Thank you, Karen. Thank you, Karen. Thank you for the question, Delegate. Yes, to your point, the question before the court in Bruin was the very precise question of, is proper cause permissible as a requirement for a concealed carry permit? There's extensive discussion because in the briefings and in the arguments, part of the reason that New York had that law for 100 years was because they have places like Manhattan and densely populated areas where the presence of guns creates a real danger. That being said, the reason to contemplate it now and address it is not because the court assessed that point specifically. There's obviously discussion of it in the opinion. It's because the upshot of the opinion, which is now it's so much easier to get a permit in places like Maryland, New York, New Jersey, et cetera, the other, what the court called may issue states, you have to now just account for how many more guns are going to be out and about on the streets in Maryland, right, all across the state. That just wasn't the case before in places like Maryland and New York. And to your point, there are certain places in either the code or in COMAR, right, in the regulations at the statewide level that do address the question, right? It's something that you all have thought about. But part of the discussion that went into the drafting and the consideration in the Senate was making sure that those things are actually codified in state law. So all of those COMAR regulations are subject to change as administrative rules. I think it would be smarter for the chambers to consider what is a smart, clear list for Maryland to create statewide rules that, again, are consistent and well-known in the way that those prior regs have been.
Okay, thank you. No, we can address that when we hear SB1. I just know that the statute already talks about you can't have a firearm in public buildings, in a public parking lot, on a public street, sidewalk, right-of-ways, in storefronts, restaurants, taverns, shopping centers. Those are already enumerated in the code, and so that was the reason for my question. But thank you.
Thank you. Thank you, Mr. Chair. And anybody who could speak to this can answer that. So one of the arguments I've heard today, and I hear this quite frequently when we talk about this topic, is that, paraphrasing, higher access to firearms results into more violence, worse outcomes. Here in Maryland, I mean, we've passed law after law. We've passed laws banning ownership completely of some firearms. We've passed ERPOs. We've passed laws against carrying in certain places. And my question is, how do you have any data that backs that up? Because in other places, they've removed the requirement to carry a permit altogether. In some states, you don't even have to get a permit. There's federal data that actually says more people carrying, they're in a place to prevent this kind of issue. So can you kind of speak to that data that leads you to believe that more access to firearms creates more danger?
Sure. So first of all, as bad as Maryland's gun violence is, statistically, it is nowhere near the top of that problem, right? In states where gun laws are laxer than Maryland, Texas, there's a whole slew. I'm happy to share some data with you, but the data shows that in those states that have laxer gun laws, their gun death rates and their gun violence rates are significantly higher than they are in the state of Maryland. So while I fully acknowledge we still have an unacceptable rate of gun violence in our state, the fact that we do have the laws that we have in place are very protective of the citizens of this state, and that is what we're looking to to fix in this scenario where we're allowing more guns to come into public spaces. We're fully anticipating that's going to correlate to a higher gun violence rate.
And it's usually exponentially higher. It's not just a little bit higher.
On a per capita basis, because in my region, Baltimore, in a city, county, it's different, but we've lost population for 60, 70 years, and we have the worst rates of violent crime that I've ever seen in my entire life. And we have, 400% legal carry now. And when we asked the state police, have you encountered any increased criminal activity due to people carrying, their answer was no. And by no, they could not cite a single case. So here you have this 450% increase in carrying. You do not see an increase in crime. And I mean, we've got daily news, and it's not just Eastern Baltimore County anymore.
So I think it's important to keep in mind that, this Bruin decision just came down less than a year ago, and the data that's out there tracks this stuff for like the decade after, right? So while they may not be able to point to data today that is saying we've seen a significant increase, it's very early days where it comes to data collection, right?
It's been 8 months.
It's been 8 months, but you're talking, so those rates of increasing violence is usually tracked over about a 10-year period.
And if I may, Delegate Grammer, just to follow up on that, like the most recent research that tracks laws that go back much farther, that have stripped back restrictions like the ones that are in yours, which is training, disqualifiers for prior convictions, especially violent conduct, has been analyzed and shown to increase rates of firearm assaults, firearm homicides at rates of 22 and 30% over years. I'm happy to share the study. So it takes time to gather that data, of course, but there's no question that when you roll these laws back, those impacts are real. And again, it says nothing to a whole host of other problems that Baltimore City has to address that we want to help and be partners to you on as well. But this is just the problem we're trying to solve in this moment.
Absolutely, and I'd love to see that. We hear news articles every day, have another 4 to 5 kids shot, and there are no permit holders that are doing so. But my second final question is, under this bill as drafted, some of our protection orders are very broad. You can actually get an order if someone is annoying you. The definition of annoying is very loose. So if we pass something along these lines, you're essentially going to disqualify a person completely from getting a permit if they annoy somebody. And I don't want to delegitimize an order that may be applicable, but do you think something as broad as that? I mean, this is very inclusive. We're talking about misdemeanors here. So do you think it's justifiable to so broadly disqualify people's right to carry completely? Because this is not a constitutional carry state. A person's only remedy in Maryland is to get a permit. So do you think taking away their ability to carry completely for something as broad as that, are you okay with that?
I think oh, go ahead, Sam.
No, I mean, I think if it's indicative of dangerousness, absolutely, right? Many of the misdemeanors that are in this bill are prohibiting anyway, so you can't have a gun, much less carry it. And the question is, again, if there's an order in here that you think is overbroad and is going to reach conduct that is not actually indicative of dangerousness or propensity to violence, happy to have that conversation. But it's a list that's curated to get to the question that's in the law already, which is we're not going to issue you a permit if upon investigation Maryland State Police determines that you have a propensity for violent or unstable conduct.
Okay.
So if something's too wide a net for that question, I'm happy to discuss it with you, but I think that's the crux of the issue.
Okay, thank you.
I'd like to add something from my own personal experience about the existing laws on the books. I've had people tell me now that we have a red flag law, the incident at the Capitol could never happen again. But the Annapolis Capitol shooter made sure no one knew he was trying to get a gun. There was nothing to report. There was no red flag to report. So what we really need is a multifaceted approach to gun violence, and like we have in this bill. So if people want to carry a gun in public, they should be able to show that they can hit their target, I mean, at the very least. And so this is one of a myriad of tools that we need in our toolbox, because one particular thing like the red flags or the other bills that are very important in their own right, that they become tools we can use to keep people alive. Thank you.
At 100%.
Thank you for listening.
Inserted tools in the toolbox that keep people alive, straight up, and keep violent criminals off the streets. I love that. The problem is every time you come to the committee with one of these bills, you're criminalizing ownership. And not only have you not accomplished your goal, you're wrapping innocent people up in this. And people are dying because allegedly they have violated some law, and that turns out not to be the case. It was a botched warrant or whatever. So, but I do appreciate your sentiments and your concern, and I do agree with that. Thank you.
Delegate Erican.
Thank you, Mr. Chair. My question is for the woman on the end there at the beginning. Do you feel that there's a community in our state that's consistently the source of over-policing?
Do I?
Yeah.
I wouldn't be qualified to comment on that. I don't.
You don't have an opinion on if there's a community of people that seem to be consistently targeted, that feel like they may be over-policed, that things in the judicial system may be significantly unfair for them?
Well, if you're asking my opinion on whether there might be people who feel that way, I'm 100% sure there might be people who feel that way, but I haven't studied it. I'm not a qualified person to comment on that.
Okay, maybe we'll ask Mr. Levy. Mr. Levy, do you have a community of people you think may feel unduly targeted in this state and other states by police observation and activity?
Do you mean gun owners, Delegate?
No, I do not, actually.
Oh, okay. I thought that's where you were going.
Nope, I'm just asking your opinion, not for you in my mind.
I'm not a criminologist delegate. I know a little bit about the system. I know that there are flaws and systemic inequities in how laws can be enforced. We're committed to making sure that any law that's enforced on our issue, and certainly any others, not speaking for the organization, for myself, are fully and fairly enforced. And so tracking and monitoring is important. Part of the text that's in the chairman's bill is about ensuring that this process is as fair and transparent as it can be, right? If you're denied a permit, you're not getting written instruction as to why. You're getting clear preparation so you can appeal to make sure that there is no unfair enforcement, that no one's being wrongfully denied permits, the permits aren't being denied disproportionately to any community in Maryland for any reason other than, the lawful reason stated in the code.
Yeah, because traditionally in Maryland, permits have been denied specifically to specific communities. In fact, it was very difficult for people living in Baltimore City to even qualify under the current recommendations in the current law, because there is nowhere to live fire any rounds in Baltimore City, and there is nowhere to get to do so from the bus system. So they are already at a disadvantage under the current law. And I have serious concerns about adding this civil protective order piece in here because, yeah, there are real issues here with having, in a divorce case, for example, where both parties will often get protective orders against each other. So now we are putting potentially women who are being victimized by their husbands in a situation where they are going to be ineligible to get a carry permit when they need it the absolute most. So is that not a concern that you see, Mr. Levy, happening with this bill?
Well, the restriction would be applied to the abusive husband, not to the victim, right?
No, this is in a situation of divorce.
Where you're saying both parties are seeking orders.
As they often do, almost always now in Maryland.
And if a court hears that case and assesses that both parties in fact pose a danger to the other, I'd posit that it's a better idea for neither party to be carrying guns in public or to have access to firearms, and that tracks restrictions that are in your code already. This is really just porting them over to ensure they're considered in this context.
Well, there's a lot of room for improvement in the divorce proceedings in Maryland and custody proceedings, and women are often treated in a way that is not equitable at all. And so the people I think who would suffer the most under this are going to be women, specifically women in abuse situations. And since everyone seems to be getting protective orders in almost every case I see now, I think it's pretty easy to say that women are going to be the ones unable to protect themselves in these situations.
Further questions for the panel? Delegate Conaway.
Mr. Chairman, thank you, panel, for coming in. So right now, we have a certain amount of gun violence, a certain percentage of gun violence rate with people that do not have a permit to have a gun. Once you start issuing more permits, would you agree that the numbers for violence will go up that are recorded as being violence because the average person who's a law-abiding citizen might try to defend themselves, and therefore they would help skew the numbers? Would you agree with that?
So I think that the data shows that whenever we do have more guns in public places, there is a wide range of what that gun violence that has escalated looks like, and it can be everything from the scenarios that you are describing to more guns are more easily stolen and entering into the criminal market. There are more access to firearms to people who are, in a normal public dispute that shouldn't end in violence, but if you've got a lethal weapon in your hand, suddenly it does. It is not just one type of violence that spikes when we see this stuff. So the scenario you're painting is a possible, is certainly a possibility, but it's only one of many.
Well, I guess what my question is, what is the problem with a law-abiding citizen having a permit to carry when they haven't shown that they are guilty of anything?
So there is no problem with a law-abiding citizen without who is in fact a law-abiding citizen,
Sure,
who qualifies for a permit to be carrying with all the proper procedures and licensing and what have you. What we're looking at in this piece of legislation, though, is taking a closer look at what is considered, who is considered to be a law-abiding citizen, right? Like, do you have a propensity for violence? Have you demonstrated through your past behaviors that there is a reason where you maybe shouldn't be bringing a firearm?
Drawn, you have no problem with it?
Correct.
Thank you very much.
And if I may, Delegate Conaway, just to follow up on your point, like the concern is not justifiable use of a firearm in self-defense, right? That's perfectly reasonable, and that's what people who choose to get wear and carry permits and carrying tend to do with their firearms. But we know from the data that the other kinds of illegal uses, firearms assault, firearm homicides, increase when states roll back these kinds of protections, and it gets easier to get a permit, and they don't have the protections that are either added in or strengthened in this bill. So that's the crux of the issue. And separately, we want to make sure that people are trained to understand that even if they think they're using their gun, or they are using their gun in justifiable self-defense, as you heard from the testimony, if that happens on a crowded street or in a crowded place, there are risks of other collateral consequences that you have to be aware of and know how to conduct yourself safely and properly if you are intending to pull that firearm out and use it.
Okay, thank you.
Thank you, Chairman. The gun violence data you alluded to earlier, is that exclusive of suicide, or is suicide included in that data? Do you break that down, separate it?
We can share some data with you that'll probably break it down more clearly. I don't want to misstate. I think the gun violence that comes out of these studies that are looking at more guns being accessible sort of run the gamut of what type of gun violence you're looking at. So I would hesitate to exclude suicide there, because whenever guns are more accessible to people who are in distress, that can be, a risk.
Thank you, but I think it'd be helpful for us as policymakers to see the difference.
Sure.
When we're talking about gun violence, I think of gun violence on the street, not someone with suffering mental health issues committing suicide. So it'd be helpful for us if we see the difference in the two.
So, and I believe my written testimony probably links some of the data that could at least get you started before I can share anything more with you if you want to take a look at that. And I'm guessing some of the others probably have linked data as well in their written testimony, but certainly happy to follow up with you.
Thank you.
Thank you, Mr. Chair. I'm happy to be a co-sponsor in this bill. Just a quick question. I'm sorry I didn't write down your name. Yes,
Andrea
ma'am.
Shambly.
What's your
Andrea Shambly.
Ms. Shambly?
Yes.
Okay. Thank you. And so it was, very sad to hear or to, really hear about the Capitol, shooting, the Gazette, many years ago. And so do you believe this bill will be helpful based off the mental health language that's a part of this bill that would have prevented that situation? You had indicated in your testimony about him having mental disorders, and I think he was fired or something from the position. I can't remember, it was years ago, but very sad story nonetheless.
I can tell you 2 weeks after the shooting of my husband, there was another shooting from a young man from Maryland who drove down to Florida and shot up a gaming convention. And the newspapers mentioned that the mom worked at a large federal agency, which was also my large federal agency. And I found out she was 2 floors below me in my building. And I went down to tell her how sorry I was that we both are paying a price for gun violence. And the care for her son was a bone of contention between her and the son's father, and they actually divorced over it. And the son would get institutionalized, and his dad would take him out every day on the 29th day for a couple of reasons. One, that he thought boys should be boys, and 2, he didn't want a 30-day institutionalization on his record. And also, a lot of insurance companies stopped paying on the 30th day, and the price is just prohibitive. So it's certainly an important point to say that if you've been in there 30 days, that indicates that you're at a high risk, generally speaking, of harming yourself, from what I've seen in the data, not harming anyone else. Most of those people will harm themselves. But it's an important tool in the toolbox. It's not going to capture, figuratively speaking, enough people, which is why we need the other provisions in this bill. We've been talking about law-abiding gun owners, but everything in this bill is triggered by a law violation, not a law-abiding gun owner. So they've shown their willingness to injure people and engage in poor judgment in other ways and that break the law. And so I think each part of this decision tree is critically important to keep guns out of the hands of people who shouldn't have them.
Okay, thank you.
Further questions for this panel? Delegate Boucher, third bite at the apple.
Thank you, sir.
All right.
Would this panel be comfortable and happy with more law-abiding citizens being certified and qualified under this law, walking around carrying firearms?
Are you asking me, do I want more people in public spaces carrying firearms if they're legally?
In compliance with this law, would you be okay with?
Would I be happy with it?
Well, you're endorsing the law, and I'm thinking that might be the ramification. Are you comfortable with more citizens being in compliance with this law, carrying weapons in public spaces?
I think the ramifications are that's the space we are in right now, right? With the Bruin decision, there are more permits having been issued, more people starting to be in public spaces with firearms. This law is hoping to put some guardrails on that, right? I am not a fan of people carrying firearms in public spaces, but you have a legal right to do so, and that's what the Supreme Court says, so it is what it is. But I would like to see some protection going on there.
Thank you. That's a wonderful reply.
And I think the proficiency is an important aspect of this, too. It's one thing if you're missing your target shooting an intruder in your home, I suppose. I mean, obviously, you want to hit your target in that case and protect your family. You don't want to have a stray bullet hit a member of your family instead. But if you're carrying a concealed weapon in public, it's really important that you are proficient and that you hit what you're aiming at, like this poor 9-year-old girl who died from a property crime that was over, is horrifying. We're paying for this with our lives. And I think this bill will make a critical difference in this effort moving forward without interfering with any law-abiding gun owners' chance to use and become proficient and responsible with their firearm.
Delegate Kaufman.
Yes, I'm sorry, I forgot your last name, but Karen, could you answer this question for me, please? I just was thinking a lot about what Delegate Grammer said, because he's a very thoughtful person, about the violence in Maryland and Dundalk and Essex, which he represents, and throughout the state. So, but you right here, can you hear me? I hope Delegate Grammer was able to hear the compliments. Anyway,
all the rest of us did.
But you write that in fact, Louisiana, Wyoming, Missouri, and Alabama have the highest rates of gun homicides. And I would presume, given that they're red states, that none of those states have strong gun safety measures. So can you just expand a little bit about that data? Because while I share Delegate Grammer's concern, I think it would be helpful for you to compare and contrast a little bit.
Yeah, I mean, generally.
So we can get perspective.
Absolutely. Those states are widely thought to be states that their gun protection laws, as we refer to them, are weaker than that of Maryland and other states that have stronger laws. And on a per capita basis, their gun violence rates are significantly higher. Overall, and we do have some numbers in Maryland that sort of skew our data and pull us higher than I think we would otherwise be. And this bill isn't necessarily designed to address some of those things. And, you know, our organization works on plenty of other pieces of legislation that are more narrowly tailored to address different areas of gun violence, because there is no one single fix. But those exactly are the states that I would highlight as, you know, when you're breaking it down on a per capita basis, the lax gun laws have led to higher gun violence rates.
Thank you, because would you also say that, well, you can't be right with gun safety? Well, we can't prevent things 100% of the time, unfortunately. It's better to be able to prevent tragedies as much as possible.
Absolutely.
Thank you.
Are there further questions for the panel? Seeing none, thank you all very much. We have another panel of three. James McGuire, Ellie Colmers-Cowan, and Melanie Shapiro. We'll ask them to come up, and then we're going to hear from the opponents. We're going to take the people who are in the room first, and then we'll take those people who are on virtually. And I'll give the order for that here in a moment. So I'll start with my right.
Sure.
Yes, and then go to
My
the left.
left.
So go ahead for 2 minutes. That's you.
Yep.
Yeah. Right.
Mr. Chair, members of the committee, my name is Ellie Cowan with Compass Advocacy here on behalf of Giffords, the gun violence prevention organization led by former Congresswoman Gabby Giffords. I'm here today in support of HB 824, which makes critical updates to the law on possession and licensing of firearms within the constitutionally permissible boundaries articulated by the Bruin decision from the Supreme Court. I echo what the first panel said much more eloquently than I'd ever be able to do about the benefits of this bill for all of Maryland. Bruin made it clear that many regulations implicating Second Amendment rights will survive scrutiny. The majority opinion emphasized that its holding was neither regulatory straitjacket nor a regulatory blank check, and that many common regulations, such as restriction on guns in sensitive places, could continue. It was also noted by Justice Alito that the opinion decides nothing about who may purchase a gun, what requirements must be met to purchase a gun, or the kinds of guns that can be available for purchase. And Justice Kavanaugh, joined by Chief Justice Roberts, clarified that states are still permitted to impose licensing requirements so long as they are objective and that sensitive place restrictions are constitutional. So while I'll keep it briefer than most, as a Marylander, a lifelong Baltimore resident, and the mom of a young son, I asked for a favorable report on HB 824.
Mr. Chair, members of the committee, my name is James McGuire. I'm from Iamsville, Maryland, up in Frederick County. I'm here requesting a favorable report on this bill. I think you should submit it the way it is, unedited, unaltered, and just the way it is. It represents a shining example of tell me you don't understand the Constitution without saying so. You're creating a ambiguous proficiency requirement, which is prohibited. You have carved out a class system for military service members, which is in violation of the 14th Amendment, the Equal Protection Clause. And I don't know what to say, to be honest. You all swore an oath of office. I swore that same oath, and you're in violation of that oath if you are pushing something that is unconstitutional. So, that said, put your pen to paper, sign your name, and please demonstrate to us you are either in support of your oath of office or not, and I request a favorable report.
Thank you very much. Please, Ms. Shapiro.
Thank you, Mr. Chairman. Mr. Vice Chair, members of the committee, I am Melanie Shapiro. I'm the Public Policy Director with the Maryland Network Against Domestic Violence. Here in support of House Bill 824, I'd like to thank the Chairman for an incredibly thoughtful bill that I think does an excellent job of responding to the consequences of the Bruin decision, which we are continuing to see and has a direct and detrimental impact on victims and survivors of domestic violence. I have shared with you already this week some of the domestic violence statistics in the state of Maryland. Yesterday, I believe you were all still in committee, so you could not attend the memorial service for the victims of domestic violence homicides in Maryland this past year. There were 56 deaths, including 13 bystanders and 5 children, and 30 children that were left behind as a result of that. I think that this bill, in addressing protective orders and violations of protective orders and ensuring that those individuals cannot get wear carry permits and other access, and also ensuring the ongoing responsibility to continue to check that there is no permit issued to somebody who becomes a prohibited person is imperative. to address, I believe, a comment or question from Delegate Grammer. In order to obtain a protective order, one, a final protective order, which makes you a prohibited person for the duration of the protective order, needs to be found by a preponderance of the evidence that you commit abuse. Abuse includes assault, fear of imminent serious bodily harm, an act that causes serious bodily harm, rape or sexual offense, stalking, false imprisonment, or revenge porn. The other provisions, I believe you mentioned, like a harassment, that is for a peace order, which is entirely different, and these are for intimate partners and vulnerable adults, as well as children who may be in the home. It has not been proven, as far as I'm aware from any research, that the presence of a firearm in the home increases the risk of fatality in domestic violence situations by 500%. And so it is not in any evidence that there are protective orders in all divorce proceedings. There is data tracked in terms of how many protective orders are sought and final protective orders are issued every year. So for all of those reasons, Mr. Chairman, we believe that this is a sound bill, will protect many people, including victims and survivors of domestic violence. We urge a favorable report.
Questions first for Ms. Cowan and Ms. Shapiro. Do you have a question for one of those two people?
Yeah.
Go ahead.
Okay. Hey, ladies. Okay, so I have a message that I got from a psychiatry nurse practitioner, and she's wanting to know, because this includes this new piece that says does not suffer from a mental disorder as defined in 10-101, how many of her patients, so for example, would now postpartum mothers not be eligible anymore to get carry permits? Veterans who are undergoing treatment. I pulled the code up myself. It says here mental disorder means behavioral or emotional illness that results from psychiatric disorder. It seems very broad here. So are we saying with this bill that we think anyone that's seeking help for mental health issues should be precluded from getting their wear and carry permit?
Delegate, just so I can make sure I understand your question, are you looking on page 8?
Let me see which page this is. Yes, page 8. Mm-hmm.
6.
Yeah, line 10, number 6, does not suffer from a mental disorder as defined by 10-101-12 of Health General Article.
I would need to pull up that particular section of the
Yeah,
code to see
yeah.
what 10-101-12 specifically.
It says includes mental illness that so substantially impairs the mental or emotional functioning of the individual as to make care and treatment necessary or advisable for the welfare of the individual, for the safety of the person or property of another person, I guess, another. So, are we talking about PTSD? Are we talking about postpartum depression? And are we comfortable telling these people you can't get a wear and carry permit? And just to make sure we're all on the same page, this does not prevent people from owning a firearm or having a gun. So you're not actually stopping a gun from being in the home with this law. This law is just telling people you can't carry one. So are we telling people that they can't carry one if they have a legitimate mental health condition that they're trying to get treatment for?
So if I'm reading properly,
Yep.
and I'm looking on my phone and not in Westlaw, which is where I'm most used to looking,
Yeah.
I believe it's saying mental disorder includes a mental illness that so substantially impairs the mental or
Yes.
emotional functioning of an individual as to make care or treatment necessary or advisable for the welfare of the individual or for the safety of the person or property of another. And so I believe that that's a different distinction than somebody who is suffering from a mental illness that is being treated. It's a different level of disorder that, and also in that statute, like I said, I don't have it printed out. This is in the definition section, but it's also, the definition also is referring to inpatient treatment and admission, and so I need to look at the entire context to ensure, but I don't believe that this is applying to anybody who has a mental health diagnosis, but people who have reached a different level of a mental disorder that makes them not suitable to have a firearm, much less a wear carry permit, because if they are at risk of harming other people.
I would also add on line 11, it says, and have a history of violent behavior against the person or another.
That's kind of strange, against the person or another. So just the person that they're getting,
Themselves.
who's seeking the...
Yes. Right, so it would be a twofold definition there, right?
Right.
So they don't suffer from the mental disorder as defined, and have a history of violent behavior. So they would be in some, in care, ostensibly inpatient, right? And would already have a history of violent behavior against themselves or another.
I don't read it as in care would be inpatient, but, the actual definition just says that an individual, as to make care or treatment necessary. Care or
Correct.
treatment,
Sure.
I think, is broadly defined.
Sure.
My goal of this questioning is to figure out what are we talking about?
Well,
so,
and-
what kind of diagnoses and treatment am I actually looking at once we get onto the ground level? Who is going to be excluded now? I'm just hoping somebody can tell me who these people are who we're going to now exclude.
I don't think that it is any one particular. I think it's the level of impairment of the mental or emotional functioning as the statute would define. And
Okay, so they could have any of these disorders.
So
but
it's
just-
With a history of violence.
Correct.
Okay.
I think that is the important part there. That's the qualifier.
Okay,
And
with
it's
the
not to
history of-
stigmatize anyone with a mental disorder or someone with PTSD or depression or bipolar or any innumerable mental illnesses. It's that they've demonstrated that they have a history of violence, which should preclude them from legally having a firearm. The entire bill is outlining, it's protecting people against from themselves and protecting others from them as well. And I know we've all heard innumerable stories about PTSD victims who've taken their own lives as a result of that, with guns that they own. I think that is what we're trying to capture here. And I appreciate you asking the question to clarify, because I don't think anyone in support of this bill is looking to stigmatize people with mental health issues.
Yeah, that was my hope. Unfortunately, I know that's the goal, would be to protect those people, but again, this bill doesn't actually protect them because it doesn't take their guns from them. It just tells them they can't wear it outside their house. So it's not going to affect. I know what the goal is. I think it's laudable. It's not going to do that. So just want to make sure we all understand what it's actually going to be accomplishing. It's just removing the ability for someone to carry it off property.
Sure.
They can still actually have.
But if you follow that to the logical conclusion, then why do we even have gun laws, right? If people can just
I completely agree.
I love when we sort of meet in the middle, back there, right?
But, but Delegate
Can I try and help for a moment?
Yes, please.
Great. 5133 of the public safety article, if you look at B6, it's under the subsection restrictions on possession of regulated firearms, you'll find exactly the same language as Delegate Eric Han has been asking about for the last couple minutes, that says that you cannot possess a firearm if you suffer from a mental disorder as defined under the Health General article and have a history of violent behavior. Effectively, the language that was simply moved from the one section to the other section to make it consistent between the ability to possess a firearm and to have a wear-carry permit. Isn't that so?
Yes.
Yes.
Thank you. Right answer. All right. Further questions for this panel? I was looking at Frank. All right. Without seeing no more, thank you very much.
Thank you.
We'll go now to those people testifying in opposition, and we will hear from first the people in the room. So Mr. Jocelyn, Mr. Pennack. And there were two others, Mr. Burke, Mr. Ploutz. All four of them. Then the people who are watching at home, there are 6 who have signed up to testify. I think 6, 7. No. 1, 2, 3, 4, 6. Who are testifying virtually. We'll hear from this panel, then we'll take questions to this panel, then we'll hear from those people testifying virtually and go from there. Thank you very much. And Mr. Jocelyn, please.
Thank you, Mr. Chairman. If I beg your indulgence, because Mark has so much to say on this, I would like to cede my time to Mr. Pennack. I tried, Mark.
I know.
Thank you, Mr. Chairman. John Jocelyn, speaking for 2A Maryland. 5-306 on page 7, lines 19 to 21, raises the age for a carry permit to 21. Currently, it's 18. This will impact many, many security guards, of which there are about 10,000 in Maryland right now who have carry permits. Many of them are under 21. So if this particular line is enforced, they will be forced to leave their form of employment because they'll no longer be qualified under their employer's requirements. On 5-304, we're doubling the fees. We acknowledge that. However, what isn't said is that in another section, 5-309, we're reducing the renewal time from 3 years to 2 years. So in point of fact, what we're doing is we're tripling the fee for the renewal. So it isn't just a doubling. Mr. Penick, I'm sure, is going to address that. I'd like to point out on the mental health issue, when I was on the Governor's Commission, the healthcare providers did point out that mental illness is not necessarily equated to dangerousness. You've heard that it makes permits easier to get. No, it doesn't. The requirements are still the same. What the Bruin decision did was make more people qualified to take the process, to take the training, to go through all the background checks and all the paperwork they had to do. So they're not easier to get, they're simply more available to the average citizen. It's no longer the elitist class. That concludes my testimony. Thank you very much.
Thank you, Mr. Chairman. Mark Penick, President of Maryland Show Issue. So there's a lot of issues with this bill. We outlined them in our written testimony. I wanted to focus on a couple here. First, the doubling of fees. If you look at the fiscal note, you see that the state's going to have a 100% profit off the doubling of fees. That's a violation of Cox versus New Hampshire and Murdoch versus Pennsylvania. This test is whether it causes the administrative cost of administering the fees under those cases. If you're going to get 100% profit, guess what? That's a challenge. And under the Bruin test, articulated and it's written out in my written testimony, it's an open question of whether or not that you even charge fees in the first place. So count one of the complaint will be to attach the fiscal note under Cox and Murdoch, and count two will be Bruin says you can't charge fees at all. So if you run up the cost of these permits, you're going to have to face that possibility. Two, the disqualifiers, there's a whole host of litigation now being conducted, and you'll see it in my written testimony with the actual citations to cases, where the challenge is that you cannot impose a disqualifier for nonviolent misdemeanors. Period, full stop. Now, there's a case now pending in the United States Court of Appeals for the Third Circuit called Range versus United States, in which the court heard oral argument earlier this month, in which that issue is squarely presented. If you're going to invite an awful lot of litigation, if you make these disqualifiers for minor misdemeanors, we can have long arguments about that, but certain policy choices are off the table in the parlance of Heller. So I would caution the committee before to consider that carefully before you go there. Three, so much of this bill represents existing practices. We already teach this stuff. But if you want to put it in there, fine. The state police you can trust to do their job, and they're doing it well. I thank the committee for its time.
Michael Burt, Baltimore. You have my rest of my introduction in my written testimony. Thank you, Mr. Chairman, Vice Chair, and other delegates. As has been mentioned, doubling the fee and cutting the permit to 2 years is precisely analogous to a poll tax, and that's illegal under the Constitution, under the 24th Amendment. You're charging a fee for a constitutional right. Why isn't there a $150 fee to get a voting card? Why isn't there a $50 fee to cast a ballot every 2 years? This is the same principle. Charging citizens for a constitutional right is unconstitutional. Mental disorder, page 8. We talk about this in some detail. Arachnophobia, claustrophobia, fear of clowns, and a history of violence. I'm sorry, but this language seems inappropriate because if you have a history of violence, how do you define that? If you have a person convicted of assault, murder, some other violent crime, they're already convicted and they're already prohibited. So this seems duplicative. Somehow DWI is, I agree, unacceptable for public behavior, but there's no text, history, and tradition for banning someone from possessing a firearm because he was drunk on a horse. Fees. This is already the highest fee for any license or permit in the state of Maryland at $75. Driver's license, $6 a year. security guard pays $10 for renewing a guard card. It's the same background check for a security guard as is done for a handgun permit. It's exactly the same criteria. Yet the guard gets a guard card for $10. Private detective, $10 for renewal, $15 for an original. We charge more for alarm technicians, the guys who install cameras and your home alarm system. We charge $25 for a cosmetologist or a barber. The propensity for violence in this statute and in this room and in this discussion is historically racist. It's always been used as an argument to disarm minorities. Thank you for your time. And I have some answers about the police training and some other things if anyone needs
Delegate
that.
Eric.
Thank you, Mr. Chair. Mr. Pennant, could you tell me a little bit more about the precedent that was set by both Bruin and there was another recent case, I want to say, but maybe you can explain it to us a little bit better.
So you're probably thinking of the Fifth Circuit's decision in Ramadi versus United States came down in early February.
Mm-hmm.
That case held that the disqualification imposed for domestic violence orders under 18 U.S.C. Section 922 G8 was unconstitutional. The Attorney General has vowed to seek further review of that in higher courts, and so that's still up in the air. But the disqualification imposed by this bill for that sort of order, it's also found in Maryland law, will fall if that decision is sustained. So you have similar decisions, and they're all cited in my written testimony, applying that same kind of analysis under Buren to different parts of Section 922. 922N has fallen, 922K has fallen, 922G3 has fallen, and the hits keep coming. So there is a lot of litigation going on here.
Yeah, okay, that's very helpful. I really appreciate that. And then I know you were talking about some of the other fees. Did you have any other fees you wanted to mention? Because that's a huge difference to complete your fees.
For a barber, it's $50 for 10 years.
Wow, 10 years.
But the barber requires over 900 hours of training.
Oh, well, that's very excessive, yes.
One of my
900, did you say?
Yes.
Lord.
To get a cosmetology license is, again, something around 1,000 hours of training, and it's a $25 fee for the license.
Wow.
Handgun permit, 16 hours.
Right.
And
Yeah.
yet we charge more than we charge those highly skilled specialists that you trust your health and safety with.
Mm-hmm. Mm-hmm.
And again, alarm technicians, security guards, private detectives, all of whom typically are also armed.
Right.
$10 and $15 each.
Yeah.
And
Yeah.
it's the same background check, exactly redundant with the qualifications for a handgun permit.
Right.
Except they don't have to qualify to get the guard card. They have to qualify the training for the handgun permit.
The permit, yeah.
So they carry 2 cards.
Oh my gosh.
And they pay twice, and they get fingerprinted twice.
Yeah. Yeah. All right. Well, thank you very much. Thanks for being here, you guys.
Yes.
I know you used a set of fees to kind of correlate the what you view as the excessive nature of the fees associated with carrying a handgun. I actually equate it more to driving a vehicle. And so passenger car registrations are approximately how much? No?
Registration is, I think, $128 for
135.
Okay, it changed recently, I believe.
And there is an administrative cost associated with registrations. And so my assumption is at MVA, that cost is similar to the the revenues generated from that are similar to the cost of manning that. In the footnote, it talks about, in the fiscal note, it indicates that the additional cost for doing this would be about $4.4 million. I think you mentioned that it was, that in essence, it would be 100% profit on that. I didn't see that in the fiscal note.
So if you'll look on page 1 of the fiscal note, you'll see what the expected expenditures are from the general fund and the expected revenues are from the increase in fees. And you'll see it's expected expenditures are $4.3 million. Expected revenue from the increased fees is $8.7 million. That's roughly double. And so if you're going to count the other costs, the fiscal note talks about that. Cox versus New Hampshire and Murdoch versus Pennsylvania do not allow, in my view at least, a wholesale allocation of costs that would otherwise be typically expended by the agency involved. They have to be linked to the actual cost of administrating the program, and that isn't even getting to whether or not Bureau allows that at all. So the test under Bureau does not speak in terms of reasonable regulations. It establishes a flat-lying rule that you have to allow these permits on an objective basis, and it didn't. And it very clearly says in footnote 9 that the cost cannot be unreasonable. So I think there's a good argument here on both counts. And if we do bring suit on this, it will be a lot of discovery into the state police actual costs, and the state police will have the opportunity to prove it. It will be their burden.
Thank you.
And if I may add, Delegate Phillips, the MVA fees are to maintain one of the largest databases in the state, the Motor Vehicle Administration, registration titles, licenses, permits, etc. So most of those costs are going into the software and the hardware for those computer systems. MSP uses less than 1/100 of that database size to administer handgun permits, guard licenses, private detective agencies, etc. They don't have the same sort of massive database we have in Glen Burnie and their backups involved in state police records, because the state police records rely on other agencies who maintain data, DPSCS, MVA, and of course the FBI. And driving, owning a vehicle, is a privilege, not a constitutional right.
Thank you, Mr. Chair. Couple of quick, I've got a lot of questions, but I'm going to try to get to the best ones. So just on the driver's license for 1 second and what you were saying about the 100% profit, do you know whether or not inmates still prepare license plates?
I'm sorry?
Do we still use state incarcerated resources for license plates?
Mark? Yes, we do. That's the Department of Public Safety and Correctional Services.
Right.
Yeah,
Right.
Department of Corrections, they manufacture license plates.
Right. And so MSP will not be using state incarcerated resources.
Certainly not.
And we pay those individuals like 14 cents or something ridiculous. We pay them. So
yes, ma'am.
So the resources, we can't really say apples to apples when it comes to that. The question I have is, when the fee was $75, what was the result of the court decisions of your lawsuit?
What was the result of the court decisions? I'm sorry.
I said, when the fee was $75, what was the result of the court? What was the court decision in your lawsuit?
We lost on standing on that, so it wasn't addressed on the merits. You're talking about MSI versus Hogan. So that was resolved when the state police actually produced proof and said on the HQL litigation, I think you may be referring to, that the $50 fee involved in that litigation was actually satisfied. And I think the numbers came out almost exactly to $50. So the same databases are conducted by the state police on wear and carry permits.
So my question is whether or not the court found $75 to be to have a fee associated with a permit to be unconstitutional.
The apples and oranges, the litigation.
No, it's not. I just want to know that answer to that one little question. Did the court find that $75 was an unconstitutional fee for a wear carry permit?
It didn't address it.
Thank you. That's the right answer. Okay. Second question is, do law-abiding, responsible citizens commit suicide by firearm?
Well, sure.
Okay. And my last question is, do you agree with the assumption that lax gun laws result or have states with lax gun laws have more firearm homicides?
No.
Okay, so let's talk about that for one quick second. Let me just ask you a couple quick questions. Do you know how many firearm homicides per 100,000 people between a 4-year period in Louisiana where they have a carry permit, but they have open carry allowed? Do you know how many firearm homicides there were per 100,000 people?
So I looked at this data when I testified over in the Senate. I found that Louisiana is higher than Maryland, but Maryland has a murder rate in excess, is fourth highest in the country. It far exceeds other states where open carry is permitted, far exceeds states and neighboring states like Virginia, Pennsylvania, where open carry has long been permitted without a permit.
Not actually. So let me just make sure we are talking about the same data. Because the data that I'm looking at, we have Louisiana, Mississippi, Alabama, Missouri, that have between 11 or 8.5 per 100,000 individuals, firearm homicides.
So the data I looked at had showed Maryland with a rate of 9 per 100,000 and Virginia with a rate of 5.3 per 100,000. So the assumption I draw from that is that the correlation is not causal, that you simply cannot make the assumption that carrying outside the home or anywhere else has any causal effect on the rate. And that's confirmed by the RAND study that we've talked about in the SB1 testimony, where that is also addressed by Dr. Lott's testimony. In other words, the post hoc reasoning is not causal. So
right. I understand where you're going. My data is a little bit different. I have 7.4 in Maryland, but I understand I got your answer. So death by barber blade, how many are there?
I have no idea.
I'm actually asking the gentleman on the end.
Oh, I have no idea about barber blade.
I was just wondering because you were comparing the barber license, so I thought maybe that was something we were trying to.
To my knowledge, in the last 100 years, I can't recall of any situation or story where a barber actually killed yes, I was going there, other than in fiction, yes.
Okay, thank you.
I would add that the surrounding states, Delaware, Pennsylvania, West Virginia, and Virginia, have no requirement for open carry of a handgun. And all of those states that do not require a permit to possess or carry a firearm in public have a higher crime rate than Maryland. Maryland requires a permit just to possess a loaded firearm. The other surrounding states do not.
Thank you, Mr. Chair. Gentlemen, I tend to agree with my colleague who's kind of started us out this afternoon, with the comment that nothing in this is particularly extreme, compared to other bills we've seen this session, for example. And when the chair explained it, a lot of it sounded like not such a huge deal, the price increase and things, until you started giving us examples of other licensing fees in the state, which I was unaware of. And so then when I started to look at it, kind of taken all together, I understand that it seems the goal of this bill is to inhibit people's ability to, wear and carry and obtain firearms, which I understand the impetus behind that and the motivation. But one of my biggest concerns right now for Maryland violent crime actually has to do with illegal firearms. And so I'm wondering, based on, the cases and all the work you guys have done, do you think, doing things like increasing the fees and kind of adding extra hurdles like this is, instead of having less firearms on the streets, do you think this will actually lead to more illegal firearm use?
If I may. First, the main reason for increasing fees for constitutional rights has historically been to deny citizens the ability to exercise their rights by charging them fees for, again, the privilege of voting, except it's a right. Raising the fees for a legal handgun permit is clearly, apparently, since there's no requirement by the state police in their budget request, is clearly intended to inhibit the practice of a constitutional right, whereas there's no demonstration that there's an actual increase in costs by the state police. If you look at one of the briefing files from the MSP briefing that was given earlier in the year, there are more than 100,000 permits pending with MSP at the end of 2022. showed over 100,000 permits approved. Another 110,000 permits were still pending. Those were already paid for, and they're pending completion. So those 100,000 permits presumably will be completed over the next 90 days.
So if I could add to those remarks, you'll see in my written testimony a legal analysis that any statute that's designed or enacted for the purpose or has the effect of discouraging the exercise of the right, any constitutional right, is itself illegitimate. So to the extent that this bill is motivated by a desire to minimize public carry recognized in Buren, that is constitutionally illegitimate and will not survive judicial review for that reason alone. So we talk about that in my written testimony. So much of this bill is already current practice. As the chairman points out, we have existing prohibitors. Repeating them in this bill will accomplish absolutely nothing because the state police already applied that. So allowing this people to be prohibited because of a minor misdemeanor violation, that's not going to survive scrutiny either. It's designed to minimize the number of people carried by an ad hoc belief that certain people shouldn't have it. Well, the Supreme Court's already delineated that the right belongs to all people, and the ability to limit that right is going to be struck down, as has already happened in the 8 months since then in the numerous cases I cite in the written testimony. So the idea that the state can arbitrarily start limiting the exercise of the right is itself unconstitutionally motivated.
Mr. Jocelyn, so back to the original question. If we are putting these hurdles in place when it comes to firearms, do you think it's going to increase the use of illegal firearms within the state of Maryland?
The use of illegal firearms is outside the scope of the carry permit, so no, it won't increase it at all. It will do whatever the criminals do because they operate outside the law. What I think is interesting is that carry permits came in the early 1970s. And since that time, we've had about 20,000 a year. About half of them are to security arrest or to private citizens. So we have, from the early 70s to 2013, a track record of no problems with citizens with carry permits. The training requirement didn't come in for private citizens until 2013. So we have more than half a century of experience with over 10,000 examples of things that could go wrong, and they haven't been going wrong. And I think that's what we've lost sight of. The only thing that the Bruin decision did was it made it more equitable for the private citizen who only wanted to protect his life and didn't have a business. And for years when people would say to me, how can I get a carry permit? I tell them, start a business, because the state values your purse over your person. And if you're carrying valuables or anything that could be considered a currency, you can qualify. But your life isn't sufficient. So your only alternative is to create the good and substantial.
Just for a moment, I'm sorry to interrupt, and this is important. I want to make sure that you get the chance to answer all of the questions. Delegate Simmons is going to be away from us for a little bit of time, and he is going to have to head out right now. Most of the people in the room may have seen as people were shaking his hand just a moment ago. And so I just wanted to say on behalf of the entire committee that we will all be thinking about you in the days and weeks to come, and we look forward to seeing you back as soon as possible. Thank you very much. Please. I apologize for cutting off in the middle of it, but I think I had a good reason, so that's fine.
Absolutely,
I
Mr.
even
Chairman.
have a good and
Well done.
substantial reason, but even still, that's
So,
fine. Go ahead. Thank
Mr.
you
Chairman,
very
if I
much.
could add to those remarks, I would like to refer the committee to the record that was compiled before this JPR over in the Senate on the incidents that people with carry permits don't commit crimes. They are the most law-abiding people on the surface of the planet, with a crime commission rate 1/12 that of commissioned police officers. So the fact that you have people with carry permits actually allows them to defend their lives, and they do not personally pose a risk to anybody. So the idea that you have to limit these individuals especially is ill-founded.
Yes, and
To further answer Delegate Munoz's last question, increasing the number of handgun permits across the state will decrease the number of handguns being carried unlawfully, because people who have been carrying pistols without a permit because they could not obtain one will now be encouraged to use the process to get a valid permit and then continue to carry the pistol they've always had under color of law rather than carrying it at risk of being arrested.
Yes, and several years ago in the Senate Judicial Proceedings Committee, a representative of the Baltimore City Police Department, a colonel as I recall, was asked if they could give any statistics on felons who had been arrested who were in possession of a firearm that they did in fact own, that it was registered to them. And the officer replied that he had no record that would indicate that any were. So it merely reinforces what we've said, is that the criminals are carrying, we hear illegal guns. An illegal gun is something that's banned by statute. They are carrying illegally. It's a fine definition, but when we hear the nuances, they are illegally in possession of a firearm, and that firearm may in itself be an illegal firearm. But the common denominator is they aren't permitted under law to have it in their possession to begin with because of their past criminal history.
And to piggyback on that slightly, I've been in law enforcement since the 70s. I have thousands and thousands and thousands of street arrests, as well as arrests under warrants. And I have never yet made an arrest of a person who had a valid wear and carry permit or a handgun permit or a concealed carry permit in their possession. It has never happened in my sole experience. I've arrested thousands of people with handguns in violation of their past criminal history, illegal aliens carrying handguns in violation of the Gun Control Act, but I've never actually had to arrest someone committing a crime with a valid permit.
Thank you, Mr. Chair. I was a little taken by something Mr. Pennack said, and I just wanted to get some clarity on it. You were talking about the problem with nonviolent misdemeanors being the basis of denial of a handgun permit, and suggesting that maybe even people with domestic violence issues should not be restricted from handgun ownership. And so I guess I just want to understand if it is your desire that that's where we go with this sort of policy. And I'll just flag a couple things here: nonviolent misdemeanors, bringing a firearm onto a school grounds, misdemeanor conviction. The bill itself includes conviction for improper access for a child to a firearm, a conviction, again, not an allegation. Professional shoplifting, as long as they were under $1,500 each time, multiple times under, that's a misdemeanor in Maryland. Fentanyl possession, misdemeanor in Maryland. And I'm curious if this is actually the policy you prefer, that we do not try and remove firearms and handgun permits from these folks.
So my point to my testimony, Mr. Vice Chair, was to illustrate how Buren has been applied by the courts since it was decided. My policy preferences are entirely irrelevant here, because Buren and Heller have taken these policies.
You're the one suing, though, so I don't think they're entirely
Well, I may
irrelevant.
not sue you on that. The person who's been disqualified may sue you, but they're winning. All you have to do is look at the reasoning in United States versus Ramadi to see that they're winning. And whether I think it's a good idea or whether you honestly think it's a good idea is legally irrelevant.
Yeah, okay, fair enough, thank you.
To answer that as well,
Mr. Pennack, you have had a comment about causation. What do you mean? Could you elaborate what you mean by that?
Sure, there's a common logical error called the post hoc reasoning when it's associated with, you see something happen and something else happens afterwards. And you make a correlation determination. And that's a clear logical error, and it's correlation does not prove causation. And the easiest example of that is that a hospital and sickness are highly correlated, almost 100%. But no one would seriously argue for a moment that hospitals cause sickness. And that illustrates the point that, and to elaborate on the gun situation, originally, 10, 20 years ago, there were very few states that had shell issue regimes. Prior to Bruin, 43 states had shell issue regimes. None of those states, as they moved to shell issue, experienced any problems with it. The predictions of blood in the streets never happened. And if you looked at the candid responses of law enforcement in each one of those states where that happened, they all say, well, what we feared would happen didn't happen. Now, Maryland's going to have the same experience because there's nothing special about Maryland in that regard. So issuing shell issue permits is not something to be afraid of. It's not going to be a problem. You're not going to have blood in the streets.
So it speaks to the data which I mentioned previously, in that there are states who have, you mentioned these couple states, Mississippi, Alabama, Missouri. Yeah, they have more permissive gun laws, but that does not prove out the fact that it's indicative to an increase in crime.
Exactly right. And there's studies on this, and if you look at the Brand Corporation studies that we cited in their SB1 testimony, you'll see that the data is all over the place. There is no actual cause and effect relationship.
Are there other states that are as permissible as Mississippi, Alabama, and Missouri?
25 states are now constitutional carry states, which do not require permits at all. And you'll see crime rates in those states all over the map, including many of those 25, which are states that have a much less violent crime rate than this state.
And that's what I wanted. So I want to credit Delegate Bartlett with sending this to me. This graph she sent me is amazing. This is exactly what I was looking for. And what it shows is permissibility of gun laws and then levels of crime. And what you see is the states in which you have very high levels of crime, our gun laws are all over the place. Now you have states with lower levels of crime. Get the correlation: Massachusetts, Rhode Island, Iowa, Utah, South Dakota, Vermont, New Hampshire, and Maine. Some of these have terrible gun laws. Some of these have more permissible gun laws. But the states up top, Mississippi, Missouri, Alabama, Louisiana, Maryland, and South Carolina, I think the causation that I see are areas with rampant poverty. And that's what I wanted to get at. So can you
I think that's right. Gun violence is difficult, and it's hard to say, lump it all together as, quote, gun violence, because there are different causes, different kinds of gun violence. There's gang violence, which is different than street violence for other reasons. There's suicide rates that are different from state to state. So just to say gun violence is bad and we ought to ban guns all we can is a simplistic analysis which, should be beneath this committee.
Well, I just want to, I think this is the whole question to me. And that's the big point I wanted to hammer home, and I think this chart really shows it.
I've looked at that data, Skellick, and I couldn't agree with you more.
I'll share it with everybody, anybody who wants it, but literally the states with lower levels of crime, their gun laws are all over the place. The only thing that's constant here is that these states over here are more Democrat states, and they have different laws, and these states over here are Republican states, and they have different laws.
So if you look at Vermont, Vermont's been a constitutional carry historically, ever.
Yeah.
The only one that ever has, but completely doesn't even have a permitting statute. It's the only state that doesn't. And their crime rates are a fraction of that of Maryland's, and New York's, and Massachusetts, and adjoining states. So there are sociological factors here at issue that availability of guns simply is relevant to. So that's the point that you should be taken away from the data, not that guns cause crime or guns cause violence, because they don't.
Yeah. Delegate, in 1993, the Johns Hopkins School of Epidemiology did a study on the prevalence of handguns and homicides, and they compared the various provinces of Canada to the neighboring state across the border in the United States. It's a rather extensive study, and what they found was it wasn't the prevalence of handguns, it was how assaultive were the people in those particular areas. And they made it quite clear that the Canadians, where they had homicides, were quite capable of finding other means of committing the crime, that the handgun wasn't necessarily a factor, it was the sociological makeup of the population itself. It is on my website. It's an interesting study, and it does bear upon this because they were looking at handguns, which basically is what we're talking about today.
Okay, thank you so much.
Thank you, Mr. Chair. Thank you all very much for being here. You all three mentioned
fees is a big issue and something that you think could be dispositive to the constitutionality of the legislation. The fee right now is $75, is that correct?
Correct. For initial application, $50 for renewal, $10 for duplication.
Okay.
No, with one exception, we actually collect also another $65 for the fingerprint process, and there's another fee for photographs, and there's another fee for training, and there's another fee for the HQL. So it's the $75 is only one piece of the entire cost of a $1,000 permit.
Let me just, a couple
Yes, sir.
questions on the $75, but thanks for that. Any idea when that the fee had been increased to $75?
I think 2013, if I recall correctly, but I would have to check on that to be sure.
Would it surprise you to know that it was 1982? Excuse me, 1992?
No,
Thank you,
that
Mr.
wouldn't
Chairman.
surprise me, no.
When Governor William Donald Schaefer had his administration to propose an increase?
Doesn't surprise me, nor was it particularly relevant in terms of the tests under Cox and Murdoch.
Right, but if in fact what the fiscal note says, which is that the estimate reflects a cost of hiring 39 administrative assistants, 3 management specialists, 10 troopers to handle the bill requirements, and to regularly review the information relating to the active permit holders in the process of handgun permit renewals for the 2-year period, and that's going to increase their costs by $4.4 million, which I think that we all agree. I don't think anybody has disagreed with those numbers. Why wouldn't, and if we're using $1992, we are certainly not making up the money we need to in order to just cover our costs for those kinds of things.
I read
Would
the
you
fiscal
agree?
notice telling me that the state is going to realize from the increased fees $8.7 million, and that the delta between 4.3 and 8.7 is roughly a 100% increase. So that profit, and it is a profit, is something that's impermissible under Cox and Murdoch. And it really doesn't matter what the price was in 1992.
Well, it depends on whether the costs that they're getting reimbursed for now that they're incurring even come close to the amount of money that they're bringing in, basically in $1992.
Well, if you look at the doubling, if you have existing fees, I would suggest to you that $75 and existing fee rates would bring you right into parity. So if you double the fees and you have a doubling of the profit, I mean, that's pretty close.
But William, Governor Schaefer wanted to increase it from, I think it was, what was it, from $25 originally? $50 originally to $265. And the legislature, in their infinite wisdom, decided to just allow him to increase it from 50 to 75.
And that was, of course, before Buren and made clear that was a constitutional right at issue, and Cox and Murdoch made clear that you may not impose fees on the exercise of a constitutional right. So the analysis has changed.
Thank you. Thanks.
That concludes the questions for this panel. We're going to move on to those people who are here virtually. Thank you all very much. We'll hear from Katie Novotny for 2 minutes. Who do we have, everybody who's, there's just the two. All right, we'll hear from Ms. Novotny and Mr. Amspaugh in that order. So Katie Novotny, please, for 2 minutes.
All right, good afternoon, Mr. Chair and members of the committee. My name is Katie Novotny. I'm coming to you from District 35A, and I oppose this bill. So these dramatically increased fees are simply a tool to discourage and chill application for these permits. You know, in testimony we heard from the proponents, you know, there was this fear of increased guns in public spaces. So it's obvious that this is the intent of these increased fees, is to chill the application. Regarding will this make more guns, you know, carried illegally? Possibly. There's studies that, you know, proven in the pre-shall issue world that many people carried for their own protection in areas where crime was high and they were unable to get a permit. So the 2-year renewals are a further burden to applicants. You know, aside from the increasing the frequency, further increase the costs. That doesn't even take into account the costs of the renewal classes, which can be significant. And this is a further burden to applicants, and particularly disenfranchises those in lower income areas who often live in areas of higher crime and are more in need of personal self-defense. The process is already incredibly long and drawn out, takes significantly longer than in most areas, and a 3-year renewal even, as it stands right now, is a bit of an outlier compared to most other states. Virginia, Pennsylvania, North Carolina, South Carolina all have 5-year permit renewals. It would make more sense to move to a 5-year permit renewal, further decreasing the costs assumed for the Maryland State Police. And we have enough technology that if someone commits a crime to revoke their permit, that can be done. I request an unfavorable report. Thank you.
Mr. Amspaugh, please.
Hello, everybody. My name is Brent Amspaugh. I am in Carroll County. I strenuously oppose this bill for a number of reasons. Most importantly, it's because of the fee increases. It serves as yet another barrier to the free exercise of our constitutional rights. And it puts Maryland's in jeopardy, not only in the state, but out of the state. I have my Utah permit, covers me in 33 states, cost me $65 for 5 years. I have my Maryland permit, which I was able to get in June. A month after that, I got my Pennsylvania permit. Pennsylvania cost me $25, has no training requirement, has no live fire exercise, and I couldn't get my Pennsylvania permit until I had my Maryland permit because of reciprocity. So by increasing the barrier to people freely exercising their constitutional rights in Maryland, you are putting them in jeopardy outside of Maryland. Within an hour, most of us can be outside of Maryland in Pennsylvania, Ohio, West Virginia, Virginia, Delaware, and New Jersey. And the only one of those states I'm not covered in is New Jersey, a state I never plan on going to and I never have been in for various reasons. But this covers me outside the state as well as inside the state. Maryland has proven once again that they don't care about our lives, they don't care about our property, they care about our money, which is the only thing that drives the majority of laws in this state. If I had a business where I could show constant cash flow, I could have gotten my permit 2 years ago when I applied in the first place, but I got denied on good and substantial, and all of the gun control laws this session appear to have been written to derail and neuter the Bruin decision. It does not bring Maryland in line with the Supreme Court decision. It makes things much more expensive, and it will do nothing to make us safer. Stop comparing Second Amendment protected activity with driving. They do not compare. For those and many other reasons, I urge an unfavorable review of this bill. Thank you.
Any questions for those who are speaking virtually? Okay, seeing none, that concludes those people who are here to testify on House Bill 824 and concludes the testimony on House Bill 824 for today. We're going to move on now to our next piece of legislation. This is House Bill 666. Delegate Miller, it's right there. Yes, would you tell me who you're going to bring up with you, please? Actually, why don't you come to the microphone so that I can hear who you... We need to turn on the witnesses' microphones. There we go.
Perfect.
Tell me who you'd like to have come up with you, please.
That would be wonderful. Thank you, sir. Blanca, Tara Thompson, Kate Sullivan.
Tara Thompson, Sullivan, you said?
Yep, and Kit.
Oh, Catherine Sullivan?
Yes. Yes.
Okay, and who else?
Kit Hartman.
Kit Hart. Kit Hart.
Kit Hart, sorry.
Kit Hart. And who else? One more?
Tara, did you get Tara Thompson and Blanca? Yep, Blanca. Blanca, say your last name because I will not say that correctly.
Tapawasco.
Blanca Tapawasco. Okay, that's fine. We'll hear from you, delegate, for 3 minutes, and we'll hear from everybody else for 2.
Okay,
So
wonderful. And there is an amendment that should have hit your guys' inbox. Good afternoon, Mr. Chair and Vice Chair and members of the esteemed Judiciary Committee. I am Delegate April Miller, and I am here today to ask for your favorable report on House Bill 666 with a proposed amendment to address judiciary branch concerns. We are here as concerned parents. My own son is a senior, and if we make it until graduation without a lockdown, a vaccine, or mask mandate, he will have only had one normal year of high school. For 8 years, I was a voice for parents on the Board of Ed, and I continue to be a voice for parents in Annapolis. And that is all this simple bill is really about. Parents across the state feel like their voices are not being heard. You may ask, why do we even need this bill? Up until the end of the 90s, the Supreme Court in our nation upheld that unless parents were proven to be unfit, that they had the fundamental right to direct the upbringing and education of their own child. Then in 2000, the Troxel versus Granville decision started to unravel those rights. This bill is not about directing public schools. It is about parents having a reasonable level of transparency in what their children are being taught so that they can make the appropriate educational choice for their child, whether that is home, public, charter, or private school. The state and our public schools are now passing laws and writing policies that operate under the assumption that parents are unfit. Parents are now not to be trusted with vital information about their child. Their 12-year-old can be in counseling for mental health crisis, and their 16-year-old can be put on antidepressive without the parent's consent or even knowledge. Parents are called terrorists by the NSBA when they demand curriculum transparency and have even been arrested when speaking out about their daughter being sexually assaulted at school. Parents have no say if their child checks out a book that may look like pornography, and at 11 years of age, like my middle school daughter was, students are being asked the following questions on a classroom survey with only a barely informed opt-out. Have you ever had sexual intercourse? How many sexual partners have you had? How old were you when you first had sex? And did you use a condom? Have you ever thought about killing yourself? Have you ever attempted suicide or made a plan to commit suicide? This is an anonymous survey that will not bring these kids help. Kids are being bullied, and their parents are not being told. Our special ed students are being denied the services they need, and parents are fighting for due process. Parents aren't being told that their girls are being sexually harassed or abused, even in elementary school. And by high school, currently, 57% of girls are experiencing persistent feelings of sadness and hopelessness. Kids are being trapped in failing schools with no way out. And the current juniors will graduate with an overwhelming majority not even proficient in Algebra 1. Schools are not giving parents options or remediation plans about that. Parents know their children best. They are their best advocate. 2 involved parents is the top indicator for academic success. It's imperative that we as a state affirm and enshrine the fundamental rights as parents to be the best advocates for their child. Thank you.
All right, whoever would like to go next.
Thank you. Thank you. Thank you. And then, is it okay, whoever wants to go next? Whoever wants to go next is fine. Do you want to go, Kit? Sure.
Hello, my name is Kit Hart. I'm the mother of 5 children and the chair for the Carroll County chapter of Moms for Liberty. I'm asking that you vote in favor of the fundamental rights protected by HB 666. As legislators, you have positions of honor and trust. But for those of you with children, I'm confident that your role as that you consider your role as parent to be paramount. Despite whatever titles you hold in government or business, I'd venture to guess that your responsibilities as mom or dad are the ones that you take the most seriously. And there's good reason for that. You recognize that the person who always has the best interest of your child at heart is you. You would do anything for the daughter or son you care for and nurture each day. The child you held as a baby, cheered on as they took their first steps, and loved throughout all of the ups and downs of life. I'd ask you to consider which beliefs, values, and virtues you've instilled in them. Maybe they are religious dogmas. Maybe they are your worldviews and strongly held convictions. Now imagine if another adult told your child that those views were wrong. Consider how you would feel if a government institution required you to do something to your child that you knew to be harmful. That is exactly what happened to each one of us here due to the government's response to COVID. Each day, when my preschooler came out of school with a mask soaked in saliva,
my rights as a parent were violated. When my first grader's stutter stunted his learning because he couldn't mimic speech as he learned to read, my rights as a parent were violated. When my third grader with ADHD couldn't focus due to the filthy plexiglass partitions surrounding his desk, or couldn't expend energy running around with his friends, my rights as a parent were violated. While we may not all agree on parenting styles, family values, or political viewpoints, we should all agree on one notion, that the parent-child relationship should never be severed by the government. I urge you to uphold and enshrine the fundamental rights of parents by voting favorably for HB 666. Thank you.
My name is Kate Sullivan. I'm a mother of 4 school-aged children, and I live in Baltimore County. I'm here to testify in support of HB 666. For the purposes of this testimony today, I imagined what the last 2 years would have been like had HB 666 been a well-established precept for all public policy affecting children. I thought back on the countless parents who knew, for example, that masks were harming their children, plexiglass dividers were impeding their ability to concentrate, social distancing was deeply impacting their mental well-being, and senseless contact tracing protocols were keeping our healthy children out of school. How many in this room heard over and over again, "My hands are tied, it's protocol, it's the decision of the state"? Principals, public health officials, and elected leaders made it very clear the government directives were far more important to them than the concerns of parents. Parents felt powerless against a Goliath government. Parents' pleas were ignored because, frankly, there was no reason to listen to them. HB 666 offers us a reason to listen in the future. With the passing of HB 666, the state of Maryland would recognize that our Supreme Court recognized, when it ruled Pierce versus Society of Sisters, that the child is not the mere creature of the state. Those who nurture them and direct his destiny have the right, coupled with the high duty, to recognize and prepare them for additional obligations. Additionally, 26 states have already introduced parental rights bills similar to HB 666 in their state legislature. Gloriously, 15 have signed them into law. We hope Maryland will join with these forward-thinking and common-sense leaders and vote yes in support of HB 666 and give parents a much-needed voice in the policies which affect their children. Please support HB 666. Thank you.
Yeah, whoever would like to go, she's just got to move the microphones over.
My name is Tara Thompson. I have watched parental rights be stolen from parents at every angle. Over the past 3 years, this theft has been extremely obvious. Here are a few examples. Government school closures for over a year, while private schools remained open. Parents unable to send their children to school unless they wore a mask. Parents unable to take their children to see a doctor or a dentist unless they wore a mask. This continues today at most facilities. Parents unable to renew a school contract unless they agree to vaccinate their child. This still continues today at some schools. Unable to enter businesses without providing proof of vaccine. This continues today still at some businesses. Private and public schools have allowed non-government organizations, nonprofits, and foundations to infiltrate the curriculum, the programs, and even the professional development. Institutions are teaching children what to think as opposed to how to think, and we are robbing an entire generation of children of critical thinking skills. Over the past 6 weeks, I have watched the government attempt to steal parental rights, yet again, with bills here in Annapolis. SB 378, HB 119, SB 199, SB 388, HB 265, HB 290, HB 1232, SB 372, and I could go on. In response to this, constituents have needed to request bills to be created to defend parental rights here in Maryland. HB 359, HB 757, HB 272, HB 294, HB 381, HB 666, and I could go on. It's not enough to say that our government, our institutions, and private businesses will respect and or defend parental rights any longer. We are now at the point where we need a bill to be established that a parent has the fundamental right to direct the upbringing, education, care, and welfare of their own child, and a bill to prohibit our own government from infringing upon those rights. I ask you to not only vote favorable on this bill, but I ask you to defend parental rights at all levels of government for every child and every family, because that's what we have elected you to do. Thank you.
Hello, I'm Blanca Tupawasco, and I am a mom in Baltimore City. Parents today and tomorrow will be the primary gatekeepers, advocates, and the undeniable cheerleading squad for their children. They've always been since day one. These are my two right here. One was born at 1.6 pounds, 24 gestational weeks at birth. And when I presented a written IEP requesting that the school would do an evaluation, I was given that letter back. We will observe, and we will see, and we will find if that's what your son needs. I know Americans with Disabilities Act law, not because I'm a lawyer. It's because I've been advocating for Juan for 15 years now. So I returned that letter to the principal at Highlandtown Elementary Middle School 215 in Highlandtown. And I said, you must take this letter. I am requesting, not demanding. Navigating is a daily duty for amazing parents. I have to navigate from working part-time, 1099 contract work, homeschooling my academically advanced 10-year-old who can read at the 7th and 8th grade level. So Baltimore City Public School, Patterson Public Charter said he belongs in another school like Gilman or Boys Latin, some place that I really can't afford. And so I am homeschooling my 10-year-old. And so I need to make sure that Juan, the youngest who was born at 1.6, can make all his appointments. And so who can make the best decision for Juan? Who can make the best decision for Josue? One is homeschooled, and Juan, I'm glad to share with you, it's an honor student at National Academy Foundation. I brought a copy of his grades if you would like to submit that in evidence. So we are here to ask that you would consider the one individual who is best equipped to manage all the affairs of our school, care, and management for our household, and that's the parents. Thank you.
Great. Let's go ahead and knock out a few of the online folks. We'll start with Heather Fletcher, Peggy Williams, and then Nina Villamar. In that order, you'll each have 2 minutes when you're ready, and please unmute yourself. Heather, whenever you're ready. Yep.
My name is Heather Fletcher, and
Can you try and speak louder or get closer to your microphone? We're having trouble hearing you.
can you hear me now?
Yeah, thank you.
Right. Good afternoon, Honorable Chair, Vice Chair, and members of the Judiciary Committee. My name is Heather Fletcher, and I am speaking on behalf of our Voices for Freedom. I want to thank Delegate April Miller and all the sponsors of House Bill 666, Fundamental Parental Rights, and I ask for a favorable report on this bill. United States citizens have a Bill of Rights because we have a duty to God to uphold His law. The Maryland Declaration of Rights, Article 36, states that as it is the duty of every man to worship God, we have to worship God. The Declaration of Independence says, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are the life, liberty, and pursuit of happiness. The Supreme Court states that parents have a constitutional right to direct the upbringing of their children. The Supreme Court has also held that the interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberties interests recognized by this court. Children are gifts from God to families. Our children do not belong to the federal government, the state, or any county. God gives the gift of children to parents. We are their caregivers, nurturers, protectors, and champions. The schools should focus on academics and supporting parents, but they are miserably failing at that. The numbers do not lie. Drive around Baltimore if you dare and see for yourself how well destroying the nuclear family, creating government-dependent, sexualizing children, permitting drugs and violence, pushing political ideologies, and erasing God hands out. It's like a third world country there, and it's getting worse and worse every day. Good teachers are leaving because they can't take seeing the abuse any longer. The minorities will never break free from the oppression that you have helped cause. Children in the foster care system, the children that were taken by the state to protect them, are being placed in mental health institutions because there's nowhere else for them to go. Here's quote Pamela Woods if you'd like to know more about those children. Thank you very much.
All right, Peggy Williams, when you're ready.
Can you hear me okay?
Yes.
Okay. Good afternoon, committee members. I've noticed a constant pressure to remove parents from the decision-making and the care of their children. Just recently, thankfully, a bill was withdrawn because so many parents spoke up that violated parental rights in consenting to vaccinate their minor children as young as 14. The state seems to always want to drive a wedge between parents and children, as seen by the disturbing trend to usurp parental rights, especially recently with regard to medical care. For instance, little by little, the school systems and medical industry have brought pressure for parents to vaccinate and even make it a condition to be able to attend school, in particular in the case of COVID vaccines. It is a parent's right to make all healthcare decisions for their children without fear of retribution, or in more extreme cases, to have their child removed from their custody if the state disagrees with the parent's chosen medical remedy. For instance, if my child has cancer and I choose to pursue an integrative or natural remedy, as opposed to traditional allopathic, harsher treatments such as chemo, that should be my right as a parent to pursue the medical remedy that I believe to be the best for my child without fear of medical kidnapping. Different example, there should not be any undermining of a parent's bringing up their children with their own values. I've seen children who are essentially alienated from their parents as a result of being taught by government schools that they may want to take on a different belief system from those of their parents. And this includes the practice of keeping secrets from parents, effectively driving the wedge between the parent and the child, and thereby coloring the children's minds in a way drastically different from how they've been raised at home, again usurping the parents' rights to instill in their children their values. I've noticed the increasing prevalence of mental health screening and questionnaires without parental consent in schools. It seems there is a slow encroachment of getting into the minds of the children when in fact that is not the jurisdiction or the role of the state. A parent's job is to shape how their children view the world, and the state should take no part in that and stick to academics. In closing, I've given these examples as a reason that I hope you will support Bill HB 666. Thank you.
All right, Nina Villamar.
Thank you. Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I'm Nina Villamar, and I'm the Chief of the Parental Defense Division for the Office of the Public Defender, and I'm also the mother of 2 children. We respectfully request a favorable report on HB 666. It's a codification of the supreme law of the land, and it is a reflection of Maryland's case law. It makes sense to now have a statute that expressly adopts what is the existing law. It's important to note for those who are concerned that this means that children cannot be protected, it's important to note that the statute does not mean that the parent's fundamental rights always rule. We have entire statutory schemes that say that under certain circumstances, a parent's fundamental right can be diminished to protect a child from abuse or neglect. This bill does not change those schemes. But Maryland should have a statute that makes parents' constitutional rights state law. Parents should be able to rely on Maryland's statute if they have to defend their right to make important decisions about their children's education, healthcare, religion, and their right to associate with others. A favorable report on HB 666 benefits Maryland's families, both parents and children alike, and I urge a favorable report. Thank you.
All right, now we'll have Vince McAvoy for 2 minutes.
Thank you so much, committee. I appreciate this. What got me involved with you folks down there in Annapolis was Jill Carter's bill. And Jill Carter's bill some decade ago was HB 1132, which had a rebuttable presumption of equality for parental rights. What I've seen is that as the state has denigrated father's rights, now you're going for what's left. And you got a room full of moms. We're kind of angry at the state. We're ripping off what are God-given rights. When this nation, the state was created, these were understood. It came over with the common law. The state does not give rights. The state protects rights. And we need to make it clear that there were, at the time, biological nuclear parents that has been compounded and added upon by case precedent over the founders' intentions. We have seen a state meddle as recently as last week. Thank God the bill was withdrawn. Unfortunately, the sponsor said, we're going to think about it and reintroduce it next year. This sense of waterboarding, of seesawing, where you're playing with our parental rights is unwelcome and it's unconstitutional. Further, as was, we need to get into the history of this bill just a second. It came from HB 1242 from 2020. At that time, what was going on? COVID was going on. People were finding out what teachers were teaching, so-called teaching, to our children. And it's perverse, and it needs to stop. You all have been told and warned, this is wrongful that you're doing this, and you're not standing up for parents. So we urge this bill to cement what are our rights and the rights to raise our own children. Thank you for your time.
Yeah, all right. I guess we can pause here and take some questions. Let me just take a quick inventory on how many people we have left. If we're close to finishing the favorables, we might just clear it. Do we have Ron Robusto in the virtual room? I think he was the last other person. No, okay. And do we have Janine Canito, Valerie? Okay, so we do have more in person. So why don't we take Alexandria, we'll take questions, and then we'll take the balance of the in-person favorables. Alexandria, online, you've got 2 minutes when you're ready.
Good afternoon, everyone, and thank you for the opportunity to be here. I am here to urge you to support this bill, which is long overdue in this state. Parental rights are something that predates politics and religion and have been long maintained by the Supreme Court's parental rights doctrine. However, parental rights have recently been stripped away by state overreach. The state has a duty to impose only when there is a societal consensus for what children need or there is significant risk to a child's safety. However, these conditions have not been met in any of the attacks the state has recently made on parental rights. As a parent, I am tired and I am afraid. I am tired of seeing my children being used as tools of the state, hearing the manipulation and the misinformation they are being fed each day in an effort to undermine the values in my home. I am afraid because I, the parent, am completely powerless to stop it in this state. It is not healthy to divide families like this. Children are already negatively impacted when parenting styles do not align. Imagine the impact of children witnessing their government co-parenting in direct opposition to their parents, telling them that their family beliefs are wrong. The parents and the state have the same goal, to keep the children safe and meet their needs. However, the constant overreach of the state is only causing conflict and eroding trust. Please protect our right to have a functioning family and maintain our family beliefs by passing this bill. Thank you for your time.
All right, Delegate Kaufman.
Thank you, Delegate Miller. And we spoke last night, and you said it came from the heart, and I so admire your passion, although we likely disagree on this issue. I do have some questions for you, though. I'll try to make them brief, but I do have a couple. So when people have told, I have cerebral palsy, and I was born at 32 weeks, as you know, Delegate, from our time together on the freshman tour. And so some people have told me that all I needed to do was, and I'm not mocking anybody in their beliefs, because they were sincerely compassionate beliefs, but sometimes people have some interesting theories on how I could all of a sudden walk, such as the fact that if I drank 6 glasses of milk a day, I would be able to walk without my walker, or The problem was that that I was Jewish, because if I believed in Jesus Christ, he would help me walk. And they were sincerely held beliefs. But what if I am a parent of a child with cerebral palsy, and I'm not going to get my kid physical therapy, or I'm not going to get my kid a walker or occupational therapy or whatever they may need, because I believe that glasses of milk or Jesus are going to cure my kid. And so my concern is because you said in your bill that the legislation cannot interfere with the welfare of the state cannot interfere with the welfare or the care. So isn't a kid whose parents believe that by drinking 6 glasses of milk a day they can learn to walk, so aren't they going to be in deep trouble? And my last point is, I admired the passion of the witness that indicated that she didn't like the COVID restrictions, but I think it's worthwhile to remind the body, because of the fact that this came up on the floor the other day and stuff, that the COVID restrictions were imposed by Governor Larry Hogan Jr., who, like Delegate Miller, is a Republican. Thank you.
Is that a question? Do you want me to respond or no?
Yes, Delegate Miller.
Wait, I don't know how this works in here.
No, but what do we do for somebody like me? Fortunately, for my sake, my parents didn't believe that Jesus was going to cure me or milk was going to cure me, so they got me all the interventions, and here I am because of that, with all of your, among you, because of all the earlier intervention I got and the weekly physical therapy and the 10 medications I take and different things like that. So what do we do if somebody under this bill has a sincerely held belief that I would argue is counter to the health of their kid, but they sincerely believe it, and the state can infringe under your bill on care issues?
I'd like to address you because...
I'm sorry.
Delegate Miller first, and then other people can respond. Delegate Miller first, and then other people.
You want me to go first? Okay. All right. Well, as per our conversation, you're all supposed to be nice to me, right? Remember, this is my first time doing this, okay? This is my first time. Yeah, thank you. In response to that, there are other laws as far as abuse. Some of that would constitute abuse. There are other laws on the books that this does not supersede or does not address. So there is definitely that. My other day job is I'm an eye doctor. So I completely understand as far as that aspect of it. So I believe that this is speaking solely to a individual action as far as the parent's right, but not in the cases of abuse and neglect and things like that. Or, as a matter of fact, in child custody, and as far as where the judiciary branch goes, and our public defender's office can probably give us more information as far as the legal aspect. But that is never the intent of my bill, is to leave a child in a situation like that.
Well, as we've talked about many times in this committee, respectfully, Delegate Miller, and is that court cases take a while. And abuse and neglect are sometimes ambiguous. So my concern, I appreciate that, and then after this, I'm going to be done, Mr. Vice Chair. But what you're talking about, therefore, is there may be a resolution, but for a kid with cerebral palsy or something like that, you're talking about years of litigation potentially before something is deemed as abuse or neglect. Thank you, Mr. Vice Chair.
I would like to first share that Juan has cerebral palsy as well. I would never even think that denying care for a son who doesn't just have, when I was told, oh, your son has CP, I said, what's CP? Oh, that's cerebral palsy. I'm like, okay, what is that? You know, when he was 9 months and he was limb. He also has hydrocephalus. He needs a Strata VP shunt. Dr. Ben Carson was his surgeon. I would never deny that he needs that. Never. He has 21 specialists, and he has 45 regular annual appointments. Would never, have never could never. Juan is a survivor. I'm simply his advocate. When he needed to be in school and was ready for least restrictive environment, William Baer can tell you they were sorry to see him go. It's the only Baltimore City public school that offers education for children up to 21. He was ready, and there was tears, but I did not deny that he would go then to a regular, least restrictive environment. What we're talking about is not withholding, it's preserving. We're preserving that our right, whether it's Juan or Juliet or Alan or Paul or Amit or Susana, has their parents making the decisions from healthcare to education to the values that they want to share in their home, and also the school option that's best for them.
I'd like to also add, if you don't mind, really quickly,
Briefly.
that it's two sides of the same coin. What we're all trying to prevent is a teacher telling our CP child that 7 glasses of milk will save them. That's really the big issue for someone like myself. I'll speak for myself, but I think I speak for the panel when I say that.
All right, we're going to go Valentine, Crutchfield, Erican.
Thank you, Mr. Vice Chair. My question is for the Maryland Office of the Public Defender, and I believe it's Ms. Villamar. Is that correct?
Yes, it is.
Yes, thank you. I'm reading your written testimony. I process a lot of this information by going over written testimony, and I see a contradiction in your testimony, so I just want to clarify which position you hold. The header of the testimony says, position is favorable, but the next to last line says, the public defender urges this committee to issue an unfavorable report on House Bill 666. Can you clarify that?
I saw that. Yes, I saw that right before I joined the Zoom call, and I was going to email to notify you. Our position is that we are in support of it, and we urge a favorable recommendation.
Thank you.
That was a typo at the end. Sorry about that. But I did want to answer.
Can I just pause for a second? Alexandria McCone, we ask people not to be driving their vehicles when they're doing this. Thank you. You can continue.
Can I address Delegate Kaufman's question, Mr. Vice Chair?
Yeah, briefly, please continue.
I appreciate your concern about children's medical needs not being addressed appropriately according to medical advice. And I can tell you that Maryland's Child in Need of Assistance law would not allow that to happen. There's also another statute that allows the state to ask for emergency medical care if it's a matter of life or death. But in a matter of, if there's a child with cerebral palsy, for example, and the parents are refusing to provide the child with the medically recommended care, the Department of Social Services can take immediate action to remove the child from the parent's home, go to court the very next day, and ask the court to issue an order giving the state the ability to consent to medical treatment. So it's not a protracted trial, it's not a protracted case, it can happen immediately. And the hospitals can report medical neglect because they're mandated reporters. So they can make a call tonight, DSS would go to the house tonight, and if they think the child's being medically neglected, they can remove the child, and the parties would have to go to court tomorrow, and then the court would make a determination about whether the state can continue to make medical decisions for the child.
Delegate Crutchfield.
Thank you very much, Mr. Chair. Welcome, Delegate Miller. I know you sit behind me on the floor, and we just haven't had a chance to talk. So congratulations on your first hearing. This is your first hearing? My first hearing. All right, okay. Well, you know, I guess I'm a little concerned about this bill because I've been a mother for almost 28 years. And I was pretty certain as my children were coming up that I had all the parental rights to do and to act on their behalf in any way necessary, okay? I know there are limited circumstances, you know, where, yes, the government can intervene, but I want to make sure I understand clearly here, you know, what are you saying as far as what rights I would have been expanded upon for me if I still had minor children?
Thank you. Thank you for the questions. And yes, we'll chat tomorrow. So one of the things that we're looking at with this is even in the last few years, and even as early as this session, as a bill withdrawn, that a 14-year-old would be able to consent to having the vaccine without their parents' knowledge, consent as an adult. So we're pushing this age of consent as far as psychological services, counseling, therapy, as far as medical treatment, further and further down and further younger, against people like the Board of Nurses, the Board of Psychologists that recommended when that law was passed, and Governor Hogan did sign. I don't agree with that. I'm like, this is not partisan. This is parents, and it's parents across the political spectrum. And so these are some of the rights that are being eroded as parents that I would have never thought when my kids were growing up. I would have never thought that my 12-year-old could be treated and we're going to have these community schools with health centers in the schools. We're demanding more and more school psychologists and mental health because our kids are in crisis, and I'm not going to deny that. But pushing the parents out of the situation is not the answer. Bringing the parents into the situation. So my 12-year-old could be depressed at school, could be possibly suicidal, and I might not know that. And they could be under the treatment of a psychologist, and I wouldn't even be notified. That's what we have in law right now. That's what's existing in law right now.
Well, let me just add a little bit more to that, okay? There are certain times when children don't necessarily, and I'm just going to put it out there, they may be better treated without necessarily coming to you. There are times, I'm sure, when your children don't tell you everything, okay? And that's what those laws are about, okay? Yes, you're right, there are opportunities where children can make decisions, all right? But we also want to raise children to be able to make good decisions. But with that in mind, yes, there are times. I know there are times when my children didn't tell me everything that was going on. But luckily, there was somebody else. There was a school counselor, teacher, somebody that they could go to and talk to about certain things, which is different than what you're talking about. To me, you're talking about parental rights, which I've always had. So that's why I'm saying I don't see the value in what you're trying to do here. And that's just my opinion as a delegate here, and with a vote on this committee.
Right.
Okay? So that's one thing I want to just say to you, okay? I have another question, Mr. Chair. And Ms. Villamar, you still there? Okay. I heard you answer Delegate Valentine's question earlier, but I just want to make sure I really heard you. So are you saying that you are representing the Maryland Office of Public Defenders with your testimony here today? That is the written testimony from the OPD's office that they support this bill?
That's correct.
Okay, thank you.
Can I answer the other question? I just wanted to read from you from the Board of Nursing, and that was in this bill. It said that this is the Board of Nursing, not me. The board does not believe that minors as young as 12-year-olds have the capacity to understand the processes that may be required in mental and emotional health treatments. Quote, when allowing a minor to consent to treatment, it is important to remember that although a minor may meet the legal criteria for granting consent, a psychiatrist would still satisfy him or herself that the minor patient possesses the capacity and maturity to understand what they are consenting. So even the Board of Nurses, like I said, the Board of Psychologists, they don't believe that in a lot of cases, and there was no criteria for defining that. And if you're taking, these are not just having conversations with people. This is actually treatment. This is actually therapy. This is actually your child being put on an antidepressant that might have side effects and you don't know about it, and coming home and having a reaction to those side effects and you don't even know. You don't even know that they're on that medicine, which is a whole interesting conversation. I won't get into a lot of back and forth because I know you guys love that here. But I'm just saying this is coming from other people.
Well, Delegate Miller, I just can't believe that a physician would direct your child to medication without your knowledge. Now, that's something totally different. We're going into a different strata.
I know. It's in law. That's what Maryland law is.
I'm just saying to you that, again, I just don't see the premise for this bill. I really just don't.
It's okay.
Thank you.
It's okay. Thank you.
All right, Erican and then Tomlinson.
Thank you, Mr. Chair. Thank you so much, panel, and thanks so much to the sponsor for bringing this bill. I think it's a really narrowly tailored bill that really is just codifying existing case law. That was sort of what I understood when I read it. And I'll just say we had a case where a young woman was depressed and she did kill herself, and her mother had no idea that she had been seeing the school counselor. So that happened. It happened less than 2 years ago. So it's literally happening right now in our state. So thank you so much for being brave and bringing this forward and talking about those issues. So if you could just expand a little bit more. So we talked about the mental health issues, and we talked a little bit about the COVID policies, which we did address briefly, like my colleague said on the floor, but I don't think there's been a proper apology to any of us, because peer-reviewed science is showing we were indeed correct literally the entire time. And so we're still waiting on that apology. I'm sure it'll come soon. So could you just tell me some other things that you guys might have thought about that this bill could alleviate, that we as parents have been suffering under for the last several years, with really our basic rights being violated in the state?
You can take it. Okay.
I mean, so in response, yes, thank you very much, Delegate Erickson. We just see that this is becoming more and more of a pattern, and we feel that for the parents who do not feel that their rights have been stripped away, you're very lucky. There are just many of us who feel that in many situations, whether it be, you know, covering our child's face with a mask, or being taught certain things that we just inherently disagree with, we feel like we've been taken out of the picture. And this bill is just giving us a seat at the table and roping us parents back in as the number one primary and fundamental caregiver. So
yeah, and like it was mentioned, it's really just codifying already existing case law. So well, I appreciate all of you for being here today.
I want to give an example of what a principal did behind my back, and he had to apologize for it. He took my son and spoke with him privately, and then came back to me and said, do you think that maybe he's got some kind of issue? Maybe he needs an IEP. Maybe he, you know, he seems like he's like the class clown. You know, maybe if we build a wall. And I know that some people are against walls. So I said, what are you saying? Maybe he built a wall, you know, like a wall around him. I found that completely unprofessional. And if there is a concern with any child, why is it too much to ask another adult to say, come to me? What is the concern? What did you observe? You know, was he, you know, poking somebody under the pencil, or what was going on? And that's really what this is about. I know a lot of people may, you know, say, you know, this is partisan, or, you know, this is not anything but to say the parent should be aware, acknowledged, recognized, and even supported. And I'll tell you, I'm from Baltimore City, and that is very little support. I am actually tutoring the Latrobe Holmes families who are 5, 6 grades behind in middle school. And it should be apparent to anybody. I'm the only one in Baltimore City here in this panel, I believe, that is crying out, when is Baltimore City going to make the map for care? Somebody advocating for parents, and also getting rid of the red tape that often is the school system, because we need to work together. The recipe is
okay. We got to move on to more questions, ma'am. Okay. And we got to stay on the four walls of the bill. Also, Delegate Tomlinson, and then Delegate Pasteur, and then Delegate Boucher.
Thank you, Vice Chair, and thank you, Delegate Miller, for bringing this in. I appreciate you starting off with your first bill with a nice, light,
very light,
uncomplicated topic.
Very simple bill.
Very simple bill. Appreciate it. No, I'm looking. I don't know if you were able to look at any of the written testimony that came in prior to coming in. There seems to be a lot of unfavorable testimony from different LGBTQ plus different organizations, and I'm just looking at the bill. I'm having trouble, I guess, seeing why all these organizations feel that this bill is an attack on them. I don't know. I mean, are you able to kind of address that on, why do these, why would this bill be an attack on those folks?
Well, in my opinion, I don't believe it is. Like I said, I spent 8 years on the school board. One of the things that is frequently talked about is that students who are experiencing issues as far as the growth and the changes in their sexuality and have either identified as lesbian, gay, whatever challenge that they're facing in school is that they are the highest risk group of students. And so one of their concerns is that they're afraid to tell their parents about that. And that's what we frequently hear again and again. But they need to have their rights protected from parents because they're afraid of how the parents are going to respond. And my response to that is if my child is a knowing higher risk for suicide, alcohol abuse, cutting, whatever risky behavior that would be, and the school doesn't tell me about it, and something happens where they did commit suicide or they did put themselves in harm's way, and I didn't even know, they didn't even give me the chance to help. They just assume because my child was afraid. There was a lot of things I was afraid to tell my parents growing up, back to the other delegate's point. There were a lot of conversations that are difficult to have. And I think that instead of just rejecting it outright, maybe we have those difficult conversations that say, how do we help kids navigate through that? How do we teach them that their parents may actually be incredibly supportive and they may be incredible allies? And how do we do that in a way that still respects them, but doesn't cut the parent out of the whole situation, unless you know that there's a risk or that parent is unfit. And again, we have laws and things in place and processes to do that. So that's where I'm understanding that, and they are going to be much better. Whoever is going to come and speak unfavorably, they have their own stories to tell. I am telling you my story as a parent, and it's not just me. This is coming from my sitting just this brief time, these brief weeks on Ways and Means. A lot of the testimony that I gave is actually from we voted for our Hear Our Voices Act for the young girls that had been sexually abused in schools. That is not just my testimony. I am speaking on behalf of them. And we actually passed an act earlier in our session. We passed law that we're going to be better about Title IX coordinators. We are going to do a better job of communication. The parents that are fighting for disabilities, we have had multiple bills come through Ways and Means about due process and how it's being denied. So there's so much to this. I understand that there's a lot to it, but we have to start somewhere. And this is a very narrow scope of fundamental rights where we're going to still include parents in the process of what their child is going through. Mm-hmm.
All right. Where were we? Delegate Pasteur and then Boucher. And folks, just a reminder, we still have another favorable panel and then and Conway. And
have we been up for 6 hours?
All right, let's go.
Okay. Thank you, mothers, for coming today and sharing your truth. I do like the title of this, Fundamental Parental Rights. I like it because I went to school and always felt that my fundamental rights, and I'm talking about mine, that my parents, and you can see how old I am, my parents had to fight for my rights in terms of what I was taught, because I was taught what white people, I'm just going to put it out there, what white America wanted me to know. Disenfranchising me in terms of how beautiful I am and what it is that undergirds my spirit. So they fought for it because I was blessed to have those parents who fought for it. But I understood then, and I understand now exactly what they meant. They meant that I would be able to live in a global society, and I can. So this is why I like the title. Also, having sat on a school board, what worries me is that conversations have begun to break down about what children are taught as we try to expand so that children now don't go through what I went through going to school, that they see a global world. Now, as you've all answered the questions and explained what you mean here, you have been far more articulate and definitive than what I can see on paper, because I don't know your name, I'm sorry, but you said your child had cerebral palsy.
Blanca.
You're supposed to fight for him. And if yesterday we talked about academics, right? So you were supposed to fight for him, because no school is to tell you, because your child has some disability, that he or she cannot also be intellectually astute and have that acumen. So you're supposed to fight. And you have those decisions to make about how that happens and hold them to task. You sit on Ways and Means. So you know the chair has put out a bill about who should have the burden of proof, not you. But see how that flips to the other side? Because in that case, it takes you out of the configuration. Because the bill is right that the system should have the burden of proof. Yes? Is that so? Is that so? Okay. But
I'm gonna say yes to whatever you say, ma'am.
Is that not what this is about? I'm asking that question. Do you agree that the things that I've said thus far are correct? Because you're the ones who said it. Here's the problem. The problem is when we then go into the weeds where other people might be on the other side, because there were those who still believe that my mother and father didn't know what they were talking about, even with their degrees, that they didn't know what they were talking about. They knew better what I needed to learn.
I know.
Okay, so that's a very different thing. But if we're talking masks, now I'm asking you, do you think that those parents who believe that the children should wear masks, and a lot of people really wanted schools open too, regardless, but there were a lot of people who wanted their children to wear masks. Did they have the right to articulate that?
Absolutely.
Did the system have some rights?
Yes.
Okay.
Yes.
So where was the line of demarcation? That's my problem with the bill, is that when sometimes, unless we're very specific, we start moving away to whatever our personal thing is. Would you agree? This is where I'm trying to get these questions in here.
Yes, ma'am.
It is about the issue of this.
I understand.
Do you agree? Then what is it that we do so we can make sure that all of our children, regardless of what they look like, regardless of their abilities and disabilities are, what do we do other than a bill? What do we do so that we can make sure as a civilization, as a community, that we are doing what you, Delegate Miller, and I do frequently, particularly on that bus? What is it then that we do to make sure we do have rights, regardless of our race, regardless of our economics, and that we're going to be heard? Because I'm not sure that this bill, and I don't know what a bill would really look like, because I'm about speak your truth. So I don't know that this bill or any bill is going to do it, because Delegate Ericon and I have conversations that we've never had. And what we have had it, okay, I can't ask you the question. We wouldn't have had I not become a delegate. You understand what I'm saying?
I understand.
That's my problem with the bill. But I would like to hear what else we can do to make sure that parental rights are equitable, not necessarily equal, because there's some things other people want.
And let's have a very quick response from the sponsor on that and try and keep this thing rolling.
We have a joint bill that said "Speak your truth." That is what we have. Yeah, I am happy to continue those conversations. You and I can speak for hours about that, which we don't have here. But I so respect you and the job that you have done, and you are amazing. And so anytime we spend together, I always learn something and come away from it. So keeping and continuing having those conversations, because I think that you and I do speak a lot of truth, and that's all. We'll end that.
Great. And let's go Boucher, Conaway, and I think that'll wrap this panel.
Thank you, Vice Chairman. And for the record, I believe Delegate Pastor.
Oh. That was not my fault. For the record, I believe Delegate Pastor is only 39 years old.
Yes, agreed.
Thank you, ladies, for having the courage to come forward today. It's safe to say your motivation for this bill is you no longer can trust a government that lied to you as parents for 2 years about fraudulent COVID policies that damaged your children's education and mental health.
No, not for
Yeah,
me.
well,
Not
I
for
mean,
me.
I think it for some of us, it went back further than that. But I was reflecting on the fact that a year ago today, a group of us stood outside of the Maryland State Board of Ed and really demanded that the masks finally come off our kids. That was a year ago. And we've only grown in number, and we have become an army of moms and parents who aren't going to stop. Yeah, a lot of us, the fire was ignited because of the restrictions placed on our kids due to COVID. But we're seeing that that was just a small battle in the war for parental rights, and we've only just begun. So we're just asking that that you uphold those rights and put them into law.
Thank you.
And I couldn't agree with all of what you said, but I think that the trust, it was shaken in some of the recommendations. And I think that we have to figure out how to move forward with truth and transparency and in a purposeful way. And that's what this bill is about. I've been actually fighting for these parental rights, like I said, since my time on the school board. So that was not anything, this is not anything new for me as far as fighting for parents in their education of their kids, their health, safety, well-being.
I think that all of us recognize that COVID was complicated, to say the least. And I think all of us recognize that the protocols that were put into place were probably well-intended, but they went on too long, and it was frustrating as a parent to have no voice. We were looking at our own children, knowing what was best for them, and we did not have something like HB 666 to refer to as we were working with people. And I can say for myself, I think that we can forgive, but it's really important that we don't forget. That's why we're here.
All right, Delegate Conaway.
Mr. Yeah. Panel, thanks. With the COVID mandate where you had to wear the mask, how were your parental rights infringed upon?
Well, yeah, I'll start if you want. Well, one of the things, it wasn't just my parental rights, it was my son's rights. One of the reasons why he did not play football is because one of the mandates when they started doing football, and I know this isn't a big thing for you.
No,
it's a big thing in where we live.
This is a big thing for me. So therefore, you just explained to me that you don't know. So I'll move on to my second part.
I wasn't
That's
finished.
okay. That's
Okay,
very
that's
offensive. I do know. So parents, I believe it was stated that parents know their child the best. Did someone state that? Okay. Well, if you know your child the best, then how is it that you don't know that your child can't read or write, but you live in Baltimore City and you keep seeing this on Fox 45 News, and you won't take time out and not go to the beauty parlor or not go to the barber shop and sit down and tutor your own kid? How is that?
What? Wow.
Wow.
My sons are performing 2 to 3 grades above because I homeschool.
Right.
I actually tutor. I'm not quite sure if it
Right. So
misunderstood.
this doesn't fit into you, but we keep seeing on the news how the school system is failing in Baltimore City. Is that correct?
That is correct, and we're going to be speaking on that on Thursday.
And what do we plan on doing about it?
We have a coalition of both Baltimore and Baltimore County where we actually tutor for free, sir, and we've been doing that for 10 years. But we can only reach about 30 students in a quarter, which means every time that we find that they are behind 2 to 3 grades,
Yes.
we actually tutor for free, and we've done this for 10 years.
Thank you, and I want to say you're doing a wonderful job and you're setting a beautiful example. Thank you.
I have no idea.
Uh-oh, do we have delegate tolls now?
It's just, thank you, Mr. Chair. This is really quick. Do you believe, as part of your parental rights, that your child should learn critical race theory in school?
That's not part of the bill. As far, that's not a bill. That's not part of the bill.
So the bill is silent on that. I would add that I do believe that parents have the right to transparency in what is being taught their kids. And then that way they can make an educationally informed decision on how they would like to proceed with that. And there are many options as far as education for parents.
5-2B-02 says a parent has a fundamental right to direct the upbringing, education, care, and welfare of the parent's child. Critical race theory is a level of some educational component taught in school. I'm going to ask a question again. Do you believe that critical race theory is part of with education and what you believe the fundamental right of your child and being able to be involved in their upbringing? Do you believe that should be something that you should have a right to teach or not teach in school?
I'm a mom of 3 dyslexic children here who struggle to learn to read because of the public school system. And with Maryland's reading rates being as low as they are all over the entire state, we need to get back to the basics, reading, writing, and arithmetic.
I'm not sure if my question will answer, but I will concede. Thank you, Mr. Chair.
All right, thank you very much. Oh, no, we got another one. All right, Delegate Simpson.
Man, I thought I liked our semi-chair, Moon. Thank you, Delegate Tolles. You actually, I am curious about this. We talk about parental rights, and I hear you. I do. I understand wanting to have parental control. I'm curious. I mean, it's public school. I'm curious how this is supposed to work in a classroom, in a school, if everybody is dictating, well, I want this piece of history, or I want that piece of history, or, I don't want, that is not something that has been addressed. How do you see this working, actually put into practice, this parental rights, when you're talking about education?
We're not taking it to that level. I think that, as I said in my testimony, it's not about directing the public schools. It's about directing the public schools to have openness and transparency and truth in what they're teaching to the parents. That's what it's about. We have a fundamental right to direct the education of our child, not direct the educational systems of the state. That is not our right unless you become a school board member, like Cheryl left, but unless you become a school board member, then that's a whole different story. But as far as transparency, truth, so that you can make the best educational decision for your child.
Okay, let's get specific.
Oh, no. Okay.
You just said we're not going to direct, but we're going to direct. So
no, for my child.
Okay.
Yeah, for my child.
So you got 5 people sitting there, right? We've got others. What if everybody wants something different? How is this going to work? Just give me an idea of how it's going to play out, what you want.
Yeah, yeah. The simple answer is oh, wait, sorry.
Can I chime in?
Yeah, sure.
To answer your question, Delegate, I think When there are that many opposing views and everyone wants something different, then we get back to basics. We remove anything that is controversial that some people don't like, some people do like, and we just focus on education. Does that answer your question?
No, I'd like
Okay.
to know specifically.
specific-
Give an example.
An example.
Be very specific of what you're talking about and how you would like to see it resolved.
Very specific example, 2010, when I first ran for the board, they had a program called Turk Math. It was a version of Common Core. I didn't agree with it. The board was not listening. I ran for the school board to make a difference and to determine what curriculum was put in place. Our very first meeting, we made a vote. It was removed. That was the voice of parents. It wasn't myself just doing it. It was I had the voice of the parents that were doing it. That's one way that you make a change. Another way you make a change, if I didn't like Turk Math, which is what it was called, my other option would have been to take my child out because I did not like this math curriculum. If my child was not learning. Common Core is a big piece of that mathematical failure, in my opinion. And so if I didn't like that, if I don't like what my child's being taught, then I have the option to homeschool them. I have the option to put them in private school. I have the option to get tutoring. But I have to know what's going on. I have to be involved. I have to show up, and I have to be there. But at charter school, whatever that option is, but when you're not telling me what you're teaching, then I can't make that decision. That's where it becomes a violation of parental rights.
Okay.
All right.
But you can ask, you just actually answer, which is, you do have an option. These rules are already in there for you to be able to, particularly with the education, to opt out. And
Isn't that
also
so?
to be able to
Isn't that
ask.
so? We got to ask questions. Isn't that so?
I will.
Yeah.
To be able to opt out and to actually be able to ask for the curriculum in advance. Is that not? I mean, you were on the
That's
school
not
board.
true. Yes, it's not.
You can
right.
ask what the curriculum is and be given.
They're
the
not
curriculum.
given, ma'am.
No,
They're not
There's a whole
given.
other bill about that I have. It's in transparency, but yes. No, you can't. And as far as, like I said, as far as the health care, your child could be being treated medically, psychologically, without even knowing. So So, I mean, there's a whole lot to that.
Well, we've had that discussion.
Yes, and we can again when we have more time.
Last question for the panel, Delegate Eric.
Can I chime in real quick?
Oh, thank you for the second bite, Mr. Chair. Okay, Delegate, wouldn't you say that we're so blessed to be able to have options, but there are a lot of Marylanders who are too poor to have those options. They can't pull their kids out, things like that. And those are the people who are going to most benefit from this bill. That's right. Isn't that so?
Yes.
Thank you.
I'd really like to say that I have proof that Frederick County Public Schools has lied to the parents in the beginning of the school year. They said that there would be absolutely no teaching of gender ideology in elementary school this year, and then they snuck in gender ideology, their, them, they pronouns into a first grader's math assignment. They've lied to us repeatedly. Thank you.
Seeing no further questions for this panel, we thank you all very much. We're going to move on to the next panel. So I would be Janine Canito, Valerie Walters, Susie Scott, Laura Hartman, Angela Abramovich, okay, we'll start with the person on my right, your left, and then we'll go from there.
Thank you for the opportunity to speak today. My name is Susie Scott, and I am the chapter chair of Moms for Liberty in Harford County. I respectfully request a favorable report for House Bill 666. It should be self-evident that parents hold the sacred and primordial right over the upbringing, education, and medical care of their own children. Yet, over the past several years, parents have seen their rights usurped. We are seeing this especially in the policies and regulations being implemented in our public schools. And we're seeing it in some of the legislation that is being proposed by this General Assembly. We have arrived at this point in time where legislation is needed by the parents of the state of Maryland to affirm their rights to make reasonable decisions for their children. It used to be well understood that schools play a supportive and a complementary role in the process of raising children up to adulthood. Somewhere along the line, this understanding has become lost. Experts in our schools, experts in government, have decided that they know better than parents, and this trend must be halted. This is not a partisan issue. Parents in this state come from many and diverse backgrounds, and parents will also have diverse ideas about the way to parent. Yet we all can agree that as the parent, we hold the primary place and responsibility as the caregivers of our children. There are few things you delegates can agree on. If there is one thing, let it be this. Can we all agree that as the parent, we are the primary caregivers of our children? The parents of Maryland need you to affirm parents' fundamental rights over the education and upbringing of their children. Please give a favorable report to House Bill 666. Thank you.
Do I have to push anything? Can you hear me?
No, and I'm reacting that way because when you press something, the whole thing breaks down, literally. So please don't do that.
I won't touch it.
Okay, don't, yes. Go ahead.
I have to be honest, when I first read HB 666, I thought, who would oppose a parental rights bill? Like, this is kind of a no-brainer, right? We'll be here for a couple of minutes. I'm well aware the Supreme Court has set precedents, over the past 100 years, and have even went as far as to say parental rights have been established beyond debate. Great. However, the current public school system did not get that memo. They absolutely did not get that memo. And this is very clear in the parental trenches. And I just want to reinforce that those of you who have grown kids, the parental trenches now are nothing like what you probably encountered. This is a whole different ballgame. Our Hartford County Superintendent of Schools guards the titles of books in the school libraries like they are CIA classified material. It's ridiculous. It's like if he shows us, he's going to have to kill us or something. Why? Maybe. Call me suspicious, but we did find out that there are pornographic books in our elementary school, middle school. Many years ago, I worked for the Marine Corps New Parent Support Program, and if during a home visit, I saw those books in the home at that time, I would have been mandated to make a report to Child Protective Services and Military Command. Doesn't matter if it's a cartoon or not. Pornographic images are pornographic images. We're in the midst, whether you're aware or not, of a monumental social, moral shift here. And we really need you to vote in support of this. Should I finish? I'm sorry. Janine Canito from Hartford County.
Thank you very much. Please go ahead.
Thank you. I'm Laura Hartman, and I'm a lifetime resident of Maryland. I'm here to testify for what I believe is the fundamental right of every parent. As mammals, the basic biology of parents is to feed, nurture, and protect their young. Each species handles this differently, obviously, but in a civilized society like ours, parents and families take on this vital role. The valuable bond between parent and child is something I didn't fully understand until I became a mother. Parents come in all shapes and sizes, and we want to celebrate that. We want to further instill the Supreme Court's decision to recognize parents. While there are many divisive issues in the world of politics, God bless you all for being in it, parental rights are not one of them. Parents should be involved and have legal rights to raise their children and their family as they see fit. A 2010 Zogby poll shows that 94% of the population believes that parents have the constitutional right to make decisions for their children without government interference, obviously unless there's proof of abuse or neglect. Many studies show that children do not have fully developed brains until the age of 25, yet we don't ensure the people tasked with guiding their decisions have legal rights to protect their children. I'd like you to think back to when you were a child. Can you imagine if your parents weren't there to help you make decisions, to teach you right from wrong with love and protection? Parents are there to guide their children through right and wrong, hope and sadness, grief and joy, and most importantly, through safety. Now imagine now, when you find out your child's teacher is teaching your child something against your values, and you ask for the curriculum, and you want to talk to someone to better understand, to have a conversation with your child about their questions, and the school won't give it to you, or they ignore you. This has happened many, many times. I'm asking you to vote favorably for HB 666. Thank you. I'll just switch so you can listen.
Good afternoon. My name is Valerie Walters. I'm here asking you to vote favorable for the Parental Bill of Rights, HB 666. I'm here on behalf of myself and many other parents far and wide that have similar values and issues with our public education system. For decades, Americans have witnessed the wide-scale erosion of parental rights, and even more so over the past several years. A hodgepodge of judicial decisions has called into question the common law presumption of parental competence that undergirds our Constitution, leaving one to wonder whether parental rights are still considered fundamental. Well, they are. The liberty of parents to direct the upbringing, education, and care of their children is a fundamental right. In 2000, the Supreme Court cited a long train of previous cases which showed that the right of parents to direct the education and upbringing of their children is a fundamental right. Parents must have the right to make reasonable choices for their child in public schools, such as the choice of opting their child in or out, preferably in. Ask me about that later, I dare you. To programs that parents find objectable and morally offensive, such as having transparency with school administrators and counselors in regards to mental health, such as not imposing unnecessary medical experiments as seen with the mask and shots, such as not allowing the dangerous sexualization of immature, moldable, innocent brains and the sharing of pornography with minors. Parental rights are the functional equivalent of the right to breathe, a right so obvious and fundamental as to be unnecessary to mention. But just in case future generations might have any doubts, the framers ratified the Ninth Amendment, which states, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In sum, parental rights have long been recognized as implicit in the concept of ordered liberty. Because fundamental rights are so important to our freedom as Americans, the government must meet a heightened burden of proof in order to restrict those rights." Furthermore, the United States Supreme Court has said very clearly that children do not have constitutional rights to their best interest. The best interest of a child is not a constitutional right that any child has. They have the same right to life, liberty, property that you and I have. They have the right to pursue happiness as soon as they are able to take on the responsibility. They do not have the right to their best interest, but rather we as parents have their best interests at heart, and that entails protecting them from government overreach. I am asking you to vote favorable.
Delegate Erican, please.
Thank you, Mr. Chair. I just wanted to say hi to my friends from Harford County. Welcome, ladies. So a couple of months ago, under the previous administration, Governor Hogan banned the use of TikTok on state devices, saying that it was a threat to security. This week, I got a text from a friend who has a child, a middle schooler, in a Maryland school, whose health teacher during health class, which is now mandated to be a full year, instructed the students to use their personal devices to go to TikTok and look up what's trending in health. So instead, she texted her mother because she wasn't allowed to be on TikTok. So is this the kind of thing that worries you as parents, that the teachers are blatantly ignoring advice from our executive level and are doing things like directing young children to TikTok to look up health?
When the administration in the school has TikTok challenges throughout the school for the teachers, instead of focusing on academics and reading and writing, there's a huge problem. And they actually posted on Facebook under their Facebook page of Kent County High School. Yeah.
Wow.
That's a problem.
Yeah, that's really disturbing.
I have some real concerns about, in terms of teachers, counselors, encouraging kids to keep secrets about things. I'm a psychiatric nurse practitioner, so kids tell me all kinds of things. And what I say to them very clearly is, we can talk to your parents together about this because they're your parents, or I will have a conversation with your parents. And that's, for as long as I've been practicing, that's what we do. Encouraging kids to keep secrets. Now, some of you may think this is a stretch, but that is grooming behavior.
Yeah.
You can raise your eyebrows, but that is what groomers do. So it's really troubling. It's getting almost sneaky.
Yeah. Starting to feel very scary to raise kids in America today. Thank you, ladies, for coming in.
I would also just add that there are things that are being taught as programs now in school where the curriculum doesn't cover particular topics that a school or a teacher or a department want to teach. And when parents ask to see it, again, when a child comes home and says, "Mom, I don't understand what Mrs. Jones was teaching today," you know, thank God that they do talk to us, because we all know that we didn't do that or always. Then you ask the school for it, and they won't give it. They ignore you, and they won't give it to you. And so, you know, whether it's amazing material or not is not the argument. It's really just, can I be an effective parent, and am I risking breaking the law because I don't even know what's going on? So, you know, it snowballs into a lot of potential issues. And if they're teaching things that are written in the curriculum, we have a process. Why wouldn't you show it to me? So I think that's a fundamental piece I think that parents are struggling with. How can I be an effective law-abiding citizen as a parent when I don't know what's happening? So thank you for your question.
Seeing no further questions for this panel, we thank you all very much for your testimony today. All right, I believe that's all those people who have signed up in favor for the bill. Go to the unfavorables now. Ayo Kimathi, Lee Blinder, and then we have a number of people virtually. Nicole Hollywood, Rosie Bean, Cassandra Dasher, and Lauren Pruitt. And they are going to be on the screen here momentarily, so we can... I'm sorry? For the bill, go to the unfavorables now. Ayo Kimathi. You said, what's your name again? Lee Blinder. Okay, if you are playing, if you're playing the, Nicole Hollywood. Could we mute them? If you're playing the YouTube, you need to turn it off. Thanks. Are you speaking in opposition? Yes. Okay, you can have a seat at the table, that's fine. Oh, I found you. That's right, thank you. I apologize, I missed you. Okay. Go ahead. We'll do the people who are in person, and then we'll do talk to everybody who's on virtually. So please, for 2 minutes.
Thank you. My name is Ayo Kimathi. I appreciate the opportunity to address the committee on this bill. Initially, when we saw this bill, we were excited. We thought that it provided parents rights and protected the rights. I agree with the sentiment that everybody in this room said. I agree with it 100%. After looking at it very closely, we became very disturbed because this bill did the exact opposite of what we feel the original intent may have been. We looked specifically at the section that says when the parents lose the rights in this bill. When do you lose your rights to protect your children? What does the bill say? It says when it's necessary to achieve a compelling government interest. We toiled and toiled over that because we had no clue what a compelling government interest was. So then we were going back and forth over the 666, and we started looking it up, and we just happened to look up the bills that were 666. And guess what? H.R. 6666 is a bill about the COVID-19 contact tracing. H.R. 666 was another bill out of Massachusetts that was about putting black people and prioritizing them for these injections that now people are getting myocarditis, pericarditis, and all of these negative things that are happening with these injections. So as we looked at it deeper, we said, wait a minute. What this bill actually does, something that they did not have when they rolled this thing out, which is the right to come in and jab the children. Now it puts it in black and white, where a bill that's supposed to be protecting children takes away in black and white the rights for parents to protect your children from it. Because we've just said, yeah, if the government makes the decision that you have a compelling reason, which is what, a few children die, all of a sudden, out of compelling reason, we have to come and inject all of the children. We created the bill that gave them the right to come and take our children and stick them with these bioweapon injections. So we were very disturbed when we saw what this bill could actually end up doing, and we had a problem with that. We consider this an adult child genocide bill, because as we looked at it, this bill is no different than SB 839, SB 840, SB 378, and SB 372 that we saw as well, all of them trying to do the exact same thing, which is find a way to force people to take something that people who are awake do not want to do. So we are against this particular bill. I would just ask one thing in the end. It's very fast. If we could, 2 seconds, yeah. Could we please not do any more bills with 666s on them? I think people would just in the future. Thank you.
They genuinely didn't pick that number, and okay. Next person, please.
Thank you, Chairman Clippinger. Janet Hartshee, an Assistant Attorney General on behalf of the Office of the Attorney General. And I want to address how this bill impacts the child welfare laws that we currently have in Maryland. In child welfare law, the fundamental rights of parents is recognized throughout the child welfare proceedings. But this bill, by changing the standard of proof in a child in need of assistance proceeding from what it currently exists in statute to a clear and convincing standard of proof, would shift the risk of error to the child, away from the child, and not protect the best interest of the child. Currently, in child welfare, when there's a shelter proceeding, there's a lower burden of proof, and that is to protect the child on an emergency basis. When there's an emergency situation, if the burden of proof changes in the child in need of assistance proceedings, this would have a grave impact on the state's power to protect children from abuse and neglect. So at the shelter care, which is a temporary proceeding, in Re OP 470 Maryland 225 of 2020 in the now Supreme Court of Maryland, discusses what the standard is in a shelter proceeding. Then within 30 days, there's a child in need of assistance proceeding and adjudication, where by statute under Courts and Judicial 3817, it is preponderance of the evidence. This would place, by changing the burden of proof, would change the risk of error and place it on the child and put children's lives at risk. When you get to the termination of parental rights proceeding, at that proceeding by statute, family law, 5323, it is already clear and convincing. This law should not impact children's safety and welfare, and by changing the burden of proof, you do that.
Thank you. We're now going to hear from Nicole Hollywood, and we'll make our way through the virtual testifiers. Go ahead for 2 minutes, please.
Thank you. I'm one of the virtual people. My name is Dr. Nicole Hollywood. I'm a professor in the University System of Maryland. I'm also president of the board of Salisbury PFLAG, the Salisbury, Maryland chapter of PFLAG National. At Salisbury PFLAG, we recognize that a robust curriculum builds knowledge and extends perspective. This means that students need to both be able to see themselves in what they're reading and studying as a reflection of themselves and their histories, but they also must be encouraged to see outwards and consider perspectives and experiences vastly different from their own. We also know that exposing learners to only limited and skewed versions of history, health, or literature that neglect entire populations using insular and homogeneous materials forces them to develop a skewed, inaccurate version of the diversity of our society. This is problematic for underrepresented groups, particularly LGBTQIA students and students of color, and the result is the creation of a hostile and unsupportive educational climate that research shows contributes to lower academic performance, lower GPA, increased absences, increased likelihood of school dropout, and less likelihood of attending an institution of higher education. Emboldening closed-minded people with the opportunity to object to curriculum and other materials, including books, readings, workbooks, worksheets, handouts, and digital media, based on beliefs about morality, religion, personal philosophy, or political ideology is dangerous and only promotes intolerance and tunnel vision. Accordingly, Salisbury PFLAG opposes this bill and recommends an unfavorable report in committee.
Cassandra Dasher, please, for 2 minutes.
Good afternoon. My name is Cassandra Dasher, and I live in Wycomico County. I am also here representing Salisbury PFLAG. I'm here today in opposition to HB 666. We believe that this legislation would place an undue burden on educators who are already often overextended while furthering divisions between parents and educators. Parents in Maryland already have ample opportunity to weigh in on learning materials and review classwork with the ability to provide feedback to schools and school boards. Parental rights is simply a smokescreen for certain fringe political groups to harass educators and censor history. So-called parental right bills are opposed by virtually all teachers' unions, including the National PTA, the American Academy of Pediatrics, the National Education Association, the Safe Kids Campaign, the National Family Support Campaign, the Parent Institute for Quality Education, the Children's Equity Coalition, and the National Child Abuse Coalition. Reframing the role of parents not as supporters but as adversarial watchdogs will harm our public education, hindering children's rights to a complete and authentic education. I recommend an unfavorable report by this committee.
Rosie Bean, please.
Good afternoon, Chairman and Vice Chairman and members of the committee. My name is Rosie Bean, and I'm also representing Salisbury PFLAG, and I am also an individual with disabilities representing Salisbury PFLAG. Pardon me, my speech impediment. I am in opposition today of the Parental Bill of Rights because I believe it is not in the best interest of our students and our teachers, and it takes away from our students, communication with the teachers. And it also silences the students to speak their own voices and their own opinions. And not all children are comfortable sharing everything with their parents at all times, and it takes away their anonymity. So thank you for having me today.
Lauren Pruitt, please.
Good evening. My name is Lauren Pruitt, and I'm the Legal Director for Free State Justice. I'm here today in opposition to House Bill 666. Parents already have much discretion for their children's upbringing. All parents have choices such as educational options, team sports involvement, activities participation, medical decisions, religion and the practice thereof, community involvement, access to technology and social media, friends and relationships, entertainment choices, and travel, to name a few. I have 2 children, 10 and 7, both in public school, and my experiences are vastly different than the parents testifying. The fact that the proponents of this bill believe that it would overrule the healthcare regulations stemming from a deadly pandemic is horrifying. I personally do not want random parents making decisions for my child without the appropriate professional expertise. I heard over and over regarding a parent's rights, but what about the child? Many of the processes schools have implemented give a child more discretion as far as what information to share with their parents based on each child's varying support at home. If your children are questioning your beliefs at home, I would look internally, not blame the government. If they do not want the school to notify you of issues at school, I would look internally and not blame the government. If they do not want their doctor to share information with you, I would look internally and not blame the government. Also, what about the guardians of children removed from their parents? Are we looking to give those parents over children removed from their custody these rights? And as an LGBTQIA+ advocacy organization, I would be remiss if I did not realize much of the arguments over parental rights centers on certain parents wanting to exclude the mention of our community in school curriculums and health education, or allowing their own children the freedom to be who they are, including being a member of this community. The vague, limited rights given to parents from this bill are overwhelmingly outweighed by the potential unintended and harmful consequences of this bill to our various systems and the futures of all children. For these reasons, opposes House Bill 666 and urges an unfavorable report. Thank you.
Are there questions for this panel? Delegate Conaway.
Thank you, panel, for coming to the general. Black might have triggered off some memories of the Tuskegee experiment. Can you comment on that?
Yes, sir. I really appreciate that question. And I'll answer it like this. Every bill that I've testified on has either been two things: pushing LGBT, pedophilic type of things on young people, and these injections. As it relates to being African American in the slave trade, pushing the LGBT thing, our introduction to LGBT was called slavery. We didn't have a word for that in many African nations. We don't now. So I'm offended by those things being pushed into school because it's against my culture and who I am. To your point, we've seen this very same thing with Tuskegee. So we as Black people in America are familiar with this kind of agenda being rolled out. The reason some of us got tricked with this one, we've seen it when it's happening white to Black people. What I don't think we've ever actually seen is when some group decides that they're going to do this to white people, Black people, and everybody at the same time. So as an African American, as a Black man from this country, I can see what's happening. And I think we should all be having this discussion. So thank you so much for the question.
Real quickly, at what age or what grade do you think the viewing of movies like Roots, Queen, and not to mention Hidden Colors could be taught in this school system?
Well, the first and the third one I like a lot. I think as early as some late elementary school.
Okay, thank you very much.
Yes, sir.
Seeing no more questions for the panel, we thank you all very much, and that concludes the testimony for House Bill 666. Concluding the testimony here in the House Judiciary Committee today. We will be back tomorrow at 1 o'clock. We will see you then. Thank you.